I got it. I have it. Thank you.
What?
I've only had one cup of coffee today.
Laughter's the best medicine.
I call this hearing to order. My name is Eileen Duff. I'm the counselor for the 5th District in the Governor's Council. Some of our guests and counselors are joining us on WebEx. And even though you see their name, yeah, they're there. And I will introduce the other counselors that are here in person. Counselor DiPaolo, Counselor Devaney, I'm Counselor Duff, Counselor Jubenville, Counselor Kennedy. We have Counselor Fiera and Hurley online joining us. And so I will read the governor's nomination letter. Executive Council, dear counselors, I'm pleased to nominate Sheila C. Harrington to the position of Clerk Magistrate of the Gardner District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker, Governor. So right now, before we start, I'm going to ask anyone who is here to testify, and if you're online, you can just raise your hand for or against, to stand up, raise your hand, and we'll take an oath. I swear to tell the whole truth and nothing but the truth in my testimony here today.
I do.
I do. Okay. All right. I will call our first witness, and that is Joanne Foran. Ms. Foran, you can sit over here. And the microphone is on when it's green.
It's green.
All right.
Dear members of the Governor's Council, as intimidating as this is, I am beyond excited and honored to sit here before you. I would like to offer my unsolicited but unwavering recommendation for Sheila C. Harrington for the Clerk Magistrate position in the Gardner-Massachusetts Courthouse. I am sure that you will receive many glowing recommendations attesting to her skills as both an attorney, state representative, and an overall wonderful person. But the perspective that I would like to offer you is that of being an employee in her firm. I met Sheila 25 years ago when we were both actively involved in our children's elementary school. At that time, I was president of the parent-teacher group. Even though Sheila was extremely busy as the mother of 2 young children and a practicing attorney, I knew that I could always count on her to help with the planning and execution of the numerous fundraising and social events. In June of 2001, I was employed part-time in an unrelated field when Sheila asked me to work part-time for her in assisting in the real estate area of the firm. I promptly and politely said no. I did not want to jeopardize our friendship and mix business with it. After a few discussions, Sheila convinced me to take the position. I have transitioned from part-time to full-time, and in 2006, I became her office manager. I've been proudly employed in her firm for the past 20 years. In those 20 years, I have seen the firm grow to include associate attorneys, area-specific paralegals, and multiple interns. Although we each had specific roles in the operation of the firm, the culture that Sheila created was one of a cohesive team, built around trust, honesty, and respect for each other and our clients. Each of us knew our job, but there's always such a unique cooperative spirit. We all worked together to make sure she was prepared, whether it was for court appearances, real estate closings, tort cases, and more. Her management style is such that the employees all wanted her to be the best, and we all worked towards that end. And she didn't have to ask us. And because of Sheila, we all wanted to do the best job that we could. Sheila took that unique skill of hers to the next level in 2010 when she decided to run for the position of state representative for the 1st Middlesex District. With what appeared to be seamless effort, Sheila was able to pull together numerous volunteers from 5 different towns to work tirelessly towards the common goal of seeing that she was successfully elected. Winning that election in 2010 and subsequent re-election campaigns presented certain challenges to the firm. Sheila basically now had 2 full-time jobs. Again, the staff, without hesitation, stepped up to meet that challenge. We all, without any direct overtures from her, we all worked together. It just comes down to the team culture that Sheila has created, where you have a job to do, you get the job done, and in the process, we were able to witness her success. I've also been able to witness how Sheila works with clients. Many times when the clients come to our office, they're in crisis mode. Whether it's from a emotional, highly charged domestic relations matter or a physical injury from an accident, she has the ability to make them feel safe. She takes notes and asks them all the questions that she needs so that she can be honestly and fairly represent them. As in any law firm, we don't always get the good one. And aside, regardless of personal feelings towards bad behavior of clients, which happens, she's always honest with the clients as to their expectations and her expectations of them. And she works diligently to see that they get a fair and realistic outcome. She shows compassion to her clients. She treats everyone with the same respect without fail. And of course, compassion to her staff members. She's always focused on what's doing right for the team and ultimately for her client. This level of compassion, I think, is ingrained in her DNA, and I have witnessed it from day one. I think Gardner and the associated communities will truly benefit by this level of compassion, as she's going to treat all individuals with respect, dignity, and honesty. I've always been proud to say that I work for Sheila, and I feel truly blessed to have been a part of her team. It's because of Sheila, what I thought was going to be a temporary summer job has turned into a lifelong career and a lifetime friend.
Thank you. Testimony from folks like you is actually very, very powerful with us because you see her
Every day.
every day, rain or shine,
Yep.
best, not best. Any councilors have questions or comments? So, Councilor Devaney.
Thank you. Thank you for coming.
My
Your
pleasure.
testimony means a lot because in reality, the nominee has spent more time with you than her husband.
True, true.
Now, so tell me, you heard about her temperament, and what is the one attribute you would say referring to this nominee?
One attribute in, she can multitask like nobody's business. Evident of carrying on 2 very important roles.
Right.
And in the office, it's, we get the job done without, you just know, you don't have to be told, and just, it flows smoothly. It's been an ideal place to work.
And how many years have you worked?
20.
Well, that's
20.
something. Wow.
As a matter of fact, when Sheila finally convinced me to take the job, it was in June, and I said, okay, in September, I'm going to get a real job. Every now and then I hear, so is this real enough for you?
Wow. So, firsthand, which is a concern of mine that I'm very interested in, her compassion with the people that she represented. And did you see in your 20 years that you would follow up with someone after the case was over and life goes on? Did she continue with anyone to make sure that that person was doing all right?
Oh, absolutely, especially in divorce cases. There are a lot of clients that come in that, like I said, they're in crisis mode. And she gets them through it. And especially in the divorce cases, it doesn't end. There's always modifications, there's always difficulties, and she continually checks up on one. We had one in particular, very difficult, very, very difficult case. And, this woman still continues to this day to reach out when she needs help.
Yeah.
And Sheila's there.
Well, I was impressed, and you've seen it in 22 years, the many pro pro bono cases that she's had when people don't have the money.
Oh, yeah.
Yeah. So what do you observe about that, about the people that she represented? Did they, they must have been so appreciative.
Oh, like, yes, there are some that, I mean, she goes above and beyond. This particular case, the woman had 4 children, and Sheila went and made sure that come Christmas time, she had solicited gifts so that each child had something to open on Christmas.
Right.
Those kind of actions, those kind of follow-ups.
Well, thank you. Your testimony means a lot to me. Thank you.
Counselor Jubenville.
Thank you. So you've worked with her a long time.
Long time.
Seeing her lose her temper.
No, not lose a temper.
I gotta tell you,
Well, I wouldn't say lose a temper, but be upset. Yeah.
I have been looking my whole life for a woman who doesn't lose her temper. And it's taken me to come to the governor's council
To hear that.
when a woman gets nominated for something, to hear that.
Yeah, I wouldn't say, I honestly wouldn't say lose temper. Obviously, you get upset. There are times when we're human, we make mistakes. And the culture is that, first of all, I would never hesitate to go to her and say, I screwed up, I made a mistake. And what she does, her go-to, I think, first step is, all right, what do we do to fix this? And then once we get through that and the problem is solved, it's, okay, what are we going to do so that this mistake doesn't happen again? The only time I could say she's really been upset is sometimes coming back when she feels that justice wasn't served in the case in court, that it should have gone one way and it didn't, and why didn't it go that way? And,
So clerk has to sit on hearings and people come in violation laws or even.
Mhm.
I'd like to see a clerk that gives passionate with people.
absolutely, no question, no question in my mind. I think that she'll be very fair, but she also sees the good in people. And she, like I said, even when we have the bad side, she sees the good in it and works towards that correct outcome.
Clerks have a unique position where they hear these hearings and make that doesn't make the charge have to go. A lot of young people shouldn't hearing they come to it person that this, which is a big thing today.
Mhm.
With cops in the future. You're pretty confident that she's
I
a
am.
compassionate lady?
100% confident. Yep, no question in my mind whatsoever.
Okay.
All right. Any other questions? Thank you for your testimony.
Thank you.
We will now go to our WebEx folks and Attorney Mark Bellarose.
Yes, can you hear me?
We can, Attorney. Thank you.
This is all magic to me, so if it's working, I'm appreciative, but I don't know why.
We have a staff here who has risen to the occasion of giving us great technology in this room and in this building, which is not meant for it. So thank you for being here.
My pleasure, my absolute pleasure to be here and to speak on behalf of Attorney Harrington. I'm an attorney practicing for 26 years in the Commonwealth of Massachusetts. This is my second career. Early on in my career, I did have a few cases with Attorney Harrington, but since I've moved my practice to northern Middlesex County in 2005, I don't think there's been a month where Attorney Harrington and I have not had an ongoing case or cases multiple. We actually have cases going on right now. I'm disappointed and elated. I'm disappointed that she's going to be withdrawing from the cases that I have with her right now. I'm elated that she's been applied and being looked at for the appointment of the position that she's applied for as Clerk Magistrate. Most of the work that I do is at a probate and family court and district court. So Attorney Harrington and I have had cases in both courts. Often we've had cases, particularly difficult divorce or custody cases, where there are actually parallel litigation going on, both in the probate and family court and district court at the same time. Typically, under the circumstances where one or another party has asked for a restraining order in district court. My experience with Attorney Harrington is uniformly positive. Even in the most difficult of cases, she has maintained her professionalism with me. She's able to speak with me objectively and clearly when we're speaking outside of the context of having our clients involved in conversations about the case. It's clear to me that she's able to view both sides of the case. She's able to look at her client's strengths and weaknesses as far as the case is concerned. That's not a universal characteristic, I can tell you, as far as divorce attorneys are concerned. There are some divorce attorneys who are incapable of shutting off the litigation part of their practice, and as a consequence, there's no opportunity, there's no gap for any reasonable conversation about how to reach a practical solution to some very difficult problems. And I want to be clear about the distinction between the law and the practical results. There are times where it is perverse as it may sound for an attorney to say, the practical solution is actually the better solution than what the law is leading us to. So we have been able to craft some very good agreements for parties, and the goal is always not just fixing the immediate problem in front of us, but what are we going to do to ensure that these parties can avoid a similar problem in the future. So I guess the best way to describe it is that Attorney Harrington practices, as do I, and we look at this as a holistic problem. We're not looking at a discrete issue that these people are in battle over now. Where are they going to be? Where are their children going to be 5, 10, 15 years from now? And what can we do now to avoid a problem in the future? My experience with Attorney Harrington, as far as her knowledge of the law, is also uniformly excellent. We rely upon each other in conversations on cases we're not directly involved with each other, asking questions about our perspectives, asking questions about our particular understanding of legal questions. And I consider Attorney Harrington a resource in that respect. It's clear from practice in court and litigation that she understands the law. She understands both sides of the law. She understands the nuances of the law, not just the basics of practice. And I also had a very good experience with Attorney Harrington when the federal government kind of pulled the rug out from under us on the alimony issue in Massachusetts. There was a long process to craft an Alimony Reform Act, which included reference to tax treatment of alimony payments. At some point, the federal government changed the tax treatment for alimony, making it a non-deductible payment. And Attorney Harrington was able to put together rather quickly a panel of quote-unquote family law experts at the State House, 15 or 20 family law attorneys, accountants, other experts. We all came together and had a very fruitful discussion at the State House about how to best approach the change in the law, and discussion of, how are we going to, as a community, a legal community, react to the changes in the federal tax law, so that there's at least some clarity going forward, and that change in federal law didn't completely upset the apple cart at the state court level. I'm not sure what else to say. I unequivocally support her application for clerk magistrate.
Thank you, Attorney. Questions?
I have a question.
Counsel Devaney.
Thank you. Attorney Bellerose, tell me, is there one case that you saw that Attorney Harrington had that really impressed you about her?
Yes.
Is there one that comes to mind?
Well, there's several that come to mind, but I'll use one as an example. There was a case that we had, which was one of these dueling court cases, was going on both in probate family court and also in district court. She had a client, and this is not to denigrate her client, who had severe mental health problems. He was also out of state, which made it much more cumbersome to deal with him. But I was, frankly, I was amazed at her calm. I was amazed at her ability to look at things objectively. She doesn't let me into the room of her private conversations with her client, but it's clear from the offers of settlement made to me and to my client through me that she was able to treat him as an individual, recognize his limitations, but also respect his rights and work to a reasonable solution, which we ultimately did. I mean, it's quite a long case. We were in court, I think, for a couple of years, but ultimately the case was resolved. And if somebody had asked me at the beginning of the case, I'm not a betting man, but I would have bet that it would have gone to trial. And it's because primarily of Sheila's work that it didn't go to trial.
Now, how many years have you known her professionally?
As I said before, I had a few cases with her when I started out in practice back a quarter of a century ago. I moved to northern Middlesex County in 2005, and it's been since that time that, as I said, I was looking back on our experience together for those 17 years or so, maybe a month or two here or there where we didn't have an ongoing case. Even when we don't have an ongoing case, it's not unusual for us to speak. I don't socialize with Attorney Harrington, but we are on friendly terms. We do discuss our families. We do catch up and speak with each other about the law or other issues when we don't have open cases. So it's very rare that I go a week, honestly, that I don't have a conversation with Attorney Harrington about something.
Well, thank you so much for being a witness here. It really has been appreciated.
I thank you.
Thank you. Thank you, Attorney. And now Attorney Deborah Bushnell. Can you hear us?
Can you hear
All
me?
right, thank you. Yes, we can.
I was really hoping to be there in person, and then I got the dreaded call last night that someone in my office had COVID. So here I am at home, and I'm hoping that my dog doesn't interrupt this process here. So thank you, Madam Chair and the honorable members of this council. My name is Deborah Bushnell, and I worked for Sheila for 4 years as an associate attorney in her office. I want to thank you for the opportunity. I'm really excited to come and to speak before you today about Sheila's appointment as Clerk Magistrate. As an associate in her office, we worked closely in many areas of the law. This included contentious domestic relations, restraining orders, probate, civil matters, and real estate. And I can tell you that in my experience, Sheila possesses the highest degree of honesty, integrity, and professionalism. I completely trust her, in my personal life and professional life. She's a strong leader, and as a manager, she's always made herself available for any questions or support I needed as her associate. She had the ability to oversee the entire workload of the firm, and she would delegate tasks accordingly to make the office run efficiently in order to serve the best needs of our clients. She also did this while working tirelessly in her role as state representative. She'd work many evenings after working in the firm all day. She'd be out at night, and she'd also be on the weekends working with her constituents. She'd be, marching in parades, and then she'd be back at the office. Sheila has superior communication skills, and not only as an attorney and a state rep, but as a manager. She has a vast working knowledge of the law from her many years of practicing, and also from working on the law reforms as a state rep. She can actually remember, she's a very, very, I would almost say a photographic memory. She can remember statutes, she remembers facts from cases. I mean, she just always can pull it out. Also in my experience, she has shown herself to be very fair and impartial in assessing legal issues and the merits of legal arguments. And she's a strong advocate for her clients, but always has been respectful of other people's positions or point of views. And she does see the best in people, and she gives people the benefit of the doubt. She likes to also, in my experience, she's a problem solver. So she likes to find common sense solutions in order to save people or our clients time and money. She's a strong decision maker too, and she's not afraid to make tough decisions. And so those are really her professional qualities that would make her a good clerk magistrate. But I also want to talk about her personal qualities, which would be Sheila's very outgoing. She has a great sense of humor and a very positive outlook on life. And she's a very kind and compassionate person. And in situations where there might be volatility or clients are upset, she's a very stable and calming presence. And she's great at dealing with stressful situations, because she knows that, you know, clients, people coming into our office or into a court are going through a very stressful period in their life. And she knows how to put people at ease. And she always took the time to hear a client out and so they always felt like they had her undivided attention. So, and then again, as an employee, she inspired the rest of us and motivated us to do the same. And we all wanted to kind of strive to work to her standards. Let's see, a couple more things. Again, as an employee of Sheila's, she always treated me with respect and kindness and appreciated any work I did for her. And she was always approachable and made the time to give me advice or insight on like a difficult case I may be working on. So in conclusion, Sheila's been a mentor to me and a role model, and not only for her legal knowledge and her professionalism, but for her positive approach to life and to work. And she has my highest recommendation for this position. And I'm willing to answer any questions. Thank you.
Thank you. Thank you very much, Attorney. We appreciate it. Do any of the councilors have any questions or
Right.
comments? Council Kennedy?
Your daughter didn't interrupt. How old is she?
Excuse me?
I said your daughter didn't interrupt. How
Oh,
old is she?
it was actually my dog.
Oh, your dog.
Yeah, no, the kids
How's
are
your
at school.
dog?
Yeah, the dog. My dog's 5.
All right. Thank you for your testimony.
Oh, you're
Marilyn,
welcome. It's my pleasure.
Councilor Devaney?
Thank you for your testimony. And I think what you said about Sheila Harrington being a state representative, I can identify with that. I'm a former city councilor. And you have to respect people with different positions. You have to be a problem solver. And you have to be calm when you need to be calm for people and smile. I think, you know, to me, the most important person, and no deflection on judges, but the most important person in the court is the clerk magistrate. That's the face of the court. And, you know, most people fear going to court. And if you could see a clerk magistrate there sitting and smiling and be welcoming, and I think your testimony is, you're saying that. And out of everything that you said, the most important thing to me was honesty, integrity. So thank you so much.
Oh, thank you.
Thank you. Thank you, Counselor. But before we proceed, I will let everyone know Ambassador Claire Cronin, who left for Dublin yesterday, will be calling in, but with the time difference and everything, I don't think it will be until about 11 o'clock. I do have, I'm not going to read them because there are just a plethora of these letters in support from people in the courts, from other clerk magistrates, from the entire Republican delegation, from the House Minority Leader, the Senate Minority Leader, and I can just say from all my, I am not a Republican, as many people know, but you have great broad support across this House of Representatives. And the very first text message that I got, we were still in chambers sitting when your nomination was announced, was from a man who was on the board of NAGLY. And for those who may not know what NAGLY is, it's the North Shore Alliance of Gay and Lesbian Youth. Representative Harrington is a hero in this community, in the gay and lesbian, bi and transgender community, in all of our communities. But the very impassioned speech that you gave, part of it written, part of it improved, I think, on the spot, on the transgender equal accommodation bill is legendary in that community and in this building. You alone, Representative, are really greatly credited by a community that has been treated as second-class citizens for most of their history, for changing many votes in the House of Representatives. You know, it looked like it was going to be a razor-thin margin. And after your speech, it was an unbelievable minutes-long standing ovation for you. And the number of minds you opened and votes you changed, I can only say as a member of that community, you saved lives. And as a citizen, as a person, I thank you. And I know how very important that was in how challenging to actually show courage and stand up and say, this is the right thing to do. Maybe we didn't do the right thing before. So thank you. And I want that to be in the public record of what that meant. What that meant. It was just really, I think probably one of the greatest. I didn't know you then. I hadn't ever met you. But you're legendary. I can tell you, you're a little bit of a folk hero. So, not to put any pressure on you there. So, now, is anyone else in favor? Okay, hearing none, I see there's a gentleman, Patrick Padden, who wants to testify in opposition. And come sit up here, tell us your job and your relationship to the nominee.
Thank you. My name is Patrick Padden. I'm a commercial banker.
And who do you work for?
Salem 5 Bank
In which city?
in Salem.
In Salem?
Yep. Just for your information, the packages that I had handed out to you this morning have also
Commercial.
been sent to you through email as a PDF when I found out that there were some people who were not here this morning.
Is that mic on?
It is.
Okay.
I'm a resident of Danvers, and I'm here this morning to speak in opposition to the nomination of Sheila Harrington to serve as a clerk magistrate of the Gardner District Court. For the record, I've never met Mrs. Harrington. Some relevant background information. Sheila Harrington is a former sister-in-law of my wife, Joan. Joan was married to Mrs. Harrington's brother, Patrick Curran, from 1985 to 2005. Patrick Curran filed a Chapter 13 petition for personal bankruptcy protection in November 5th of 2015, which was converted to a Chapter 7 liquidation only a few weeks later. And Curran's debts were discharged in April of 2016 per an order signed by Judge Henry Boroff in the United States Bankruptcy Court in Worcester. That is shown in your package as Exhibit A. In October of 2016, more than 6 months after Curran's bankruptcy was discharged, Sheila Harrington contacted my wife, alleging that Joan and I had engaged in malfeasance with regard to our 2013 purchase of the Curran's former marital home in Danvers. In addition to Mrs. Harrington's allegations being patently false, her contacting my wife was both illegal and abhorrently unethical. In an email to my wife, in your package as Exhibit B, Mrs. Harrington, in addition to making baseless allegations, noted that she was representing her brother with regard to the alleged issues tied to the sale of the home, and instructed my wife, quote, that all communication with regard to this matter needs to go through me, unquote. Patrick Curran's possible interest in any proceeds from the sale of the home, to the extent that those interests could be construed as an asset of Curran's, could, by law, only be represented by the bankruptcy trustee. Mrs. Harrington had no legal right to pursue anything with anyone regarding Curran's assets. This was a clear and absolute violation of the bankruptcy court's automatic stay provision, and thus illegal under federal bankruptcy law.
Can I ask you a question about that?
Sure.
When was the bankruptcy discharged?
In April of 2016.
And when was that email sent out?
That email was sent out in October of 2016.
So the bankruptcy's already closed?
It was closed.
When she sends this letter?
Correct.
Okay, go ahead. I just want to be clear. Go ahead.
That same email from Mrs. Harrington had as an attachment a Word document, Exhibit C in your package, entitled Casey Letter Re Current Bankruptcy. I think you'll agree that the document's title strongly suggests that the letter was from Curran's bankruptcy counsel, attorney Robert Casey. While that letter was not on anyone's letterhead and had no signature, there was no one in this room, or anyone else for that matter, who could read this letter and believe anything other than the letter was written to Sheila Harrington by attorney Robert Casey. Sheila Harrington wrote that letter. In doing so, Mrs. Harrington impersonated and assumed the identity of another attorney in an attempt to harass and intimidate my wife and to extort money from us in a matter that she had no legal right to pursue. Months later, in correspondence with our attorney, Mrs. Harrington denied the impersonation, and later she even suggested that the letter might have been written by her brother. In an ongoing matter outside of this building and unrelated to this morning's hearing, and wherein her authorship was explicitly proven, Exhibit F in your package, Mrs. Harrington admitted to her authorship and feebly proffered excuses for having done so. I submit to you that there is no excuse for any attorney, not to mention an elected official, to ever impersonate and assume the identity of another attorney in a scheme to intimidate and harass someone, no matter what the surrounding fact set might be. Furthermore, in a text exchange with my wife, which is in your package as Exhibit D, Mrs. Harrington stated that she would, quote, send the info from Pat's bankruptcy attorney, unquote. And in Mrs. Harrington's own words, in her filing in the unrelated matter, Exhibit E in your package, Mrs. Harrington explicitly stated that she advised my wife that she, quote, would email out the information from my brother's bankruptcy attorney the following day, unquote. One of Mrs. Harrington's excuses for her fraudulent actions was that she was looking out for her brother and acting as her brother's keeper. The fact is, to your point, as I noted above, Patrick Curran's bankruptcy had been discharged more than 6 months prior to Mrs. Harrington contacting my wife. There was nothing that she could have done to help her brother in any way in that matter.
No, except if there was a fraud in the bankruptcy court.
Correct.
Let him finish.
Yeah. Go ahead.
Based on our not falling for Mrs. Harrington's attempts to harass and intimidate us into dealing with her specious allegations, Mrs. Harrington decided to pursue the matter through the bankruptcy trustee. Please note, no one involved in the bankruptcy matter had apparently discerned any of the improprieties alleged by Mrs. Harrington. But she took it upon herself to contact the trustee and trustees council on numerous occasions, shown in your package as Exhibit H, the Chapter 7 trustee's application for compensation, to push this matter. After an action had been initiated against us by the trustees council, our attorney, who had years-long experience working with this specific trustee, informed me that a state rep named Harrington had an interest in the matter and that the trustee was having to deal with that. It is clear, based on the timing of her contacts with the trustee and trustees council, that Mrs. Harrington, a practicing attorney and an elected official in the Commonwealth, was pushing her false narrative with the trustee, despite the trustee and her counsel having found no issues prior to Mrs. Harrington's involvement. In the end, and in order for my wife and me to avoid the time and additional expense of a trial, we settled with the trustee for an amount that barely covered the expenses that the trustee and her counsel had incurred because of Mrs. Harrington pushing her fallacious allegations. Clearly, the trustee had no basis in the claim by Mrs. Harrington, but she nonetheless pursued it at Mrs. Harrington's urging and incurred fees and expenses in doing so. I appreciate the opportunity to address the council this morning, and out of respect for your time, I won't go more deeply into the specifics of these matters. Additional details are included in the package that I've provided to each of you. I assure you that my presence here this morning is not something that I take lightly. The illegal and grossly unethical intrusion into our lives by Sheila Harrington has gone on for more than 5 years, and we'd like it to be over. Mrs. Harrington has cost us a significant amount of time and money and countless hours of angst for no reason other than her desire to harass and intimidate my wife. Many of Mrs. Harrington's actions in this matter have been illegal, and all have been as unethical as anything that I ever witnessed. As you know from Mrs. Harrington's application, much of what I've outlined to you this morning is the subject of an investigation outside of this building, and which has been going on now for over 16 months. The outcome of that investigation may result in sanctions against Mrs. Harrington and may have a significant impact on her ability to practice law.
Excuse me, you're speculating right now, so I have to ask
That's what I
you
said-
not to
that's
do
what I said,
that.
May.
Yeah, you can't,
Okay.
this is, we want to hear facts. We don't want to hear speculation on your part.
Thank you. What I've described to you this morning and detailed further in the materials that I've shared with you call into serious question Sheila Harrington's integrity and character, and thus her fitness to serve for the position for which she's been nominated. These actions should unequivocally disqualify Sheila Harrington from consideration for the position of Clerk Magistrate. Lastly, it is my understanding that the responsibility of this council is to confirm without reservation nominations of candidates who have the integrity and character to honorably serve the Commonwealth and its citizens. As such, I strongly urge, at a minimum, that the council table any action on this nomination pending resolution of the other investigation. Thank you for your time.
I have a
Happy to answer any
question.
questions.
Thank you.
May-
I have a question.
Go ahead, Marilyn.
Thank you. First of all, Mr. Padden, I'm going to tell you right off, if I had a brother and he was treated so egregiously, I think I would, as an attorney, help him. I don't see anything in your statement that goes against that. Now, to me, it's just so outrageous that Sheila Harrington's brother, incapacitated, in depression, alcohol addicted, and his former wife, her sister-in-law, convinced this man to sell a house to her for $10. How can anyone justify something like that? Now, she married a few months later, and she sold the house in a short sale. You can't sell a house to a spouse in a short sale. It's illegal. Did you know that?
It is not illegal.
It is illegal. Everybody here knows, I do my investigation, and I don't say things that are not truthful. I don't think that you could say that about your testimony. It's
Well, that's not-
it's your opinion.
No.
But, to me, you're saying that it is legal to sell in a short sale to a spouse. And tell me about the $10 sale. Do you think any house today is worth $10?
My wife reached out to Mr. Curran and let him know, let me back up. Before we were married, we had the house appraised and realized and found out that it was well underwater. She reached out to Patrick Curran and asked if he was interested and gave him the facts, asked if he was interested in buying the house. He said no. He said A, he wasn't interested, and B, he couldn't. He was not working at the time. What she did was she
He
transferred.
was incapacitated.
He was not incapacitated.
Oh, really? Okay. That's your opinion. I'm talking
and-
fact.
No, you're talking opinion as well. We sent documents to Patrick Curran. He took those documents, had them notarized, and delivered them to our house. What's now our house. My wife was living there by herself at the time. We didn't convince him to do anything. We didn't talk him into doing anything.
How would you arrive at a $10?
Because you often see contracts that are in consideration of $1 that was paid, things like that. The house had no equity in it. It was way underwater. $10 was more than the equity in the house. I'll tell you that right now. But just to this point, I would submit to you that it doesn't matter what happened with that.
It doesn't? It does
No,
to
it
me?
does not. It doesn't matter how anything that happened on that side of the ledger, if you will.
And you said it's not illegal
I-
in a short sale.
That's my understanding, yes.
That's your understanding, but it's not the law's understanding.
I don't believe that, but my point is, it doesn't really matter what happened with the transaction with the house. For an attorney to impersonate another attorney, it doesn't matter what happened to lead up to that.
What proof do you have that she impersonated another attorney? I mean, do you have a tape of the voice?
No, I have a screenshot of the Word document that she sent to my wife that opens with, "Dear Attorney Harrington, as you know, my office represents your brother." And it closes with, "As you referred your brother to my office." That could only have come from one person, Attorney Robert Casey. But the screenshot that you have in your package explicitly shows that letter was written by Sheila Harrington. It was last modified by Sheila Harrington, and that is the same document that was then sent as an attachment to that email 15 minutes after it was written. I think that's prima facie evidence that
Mr.
she
Patton,
wrote the
how
letter.
would you defend your wife when she had this transaction, sold the house for $10, and she was remarried for 4 months, yet she used her former husband's name?
No, she signed the deed in the name that was on the deed, and that was Joan Curran.
And you're not responsible. I mean, I have a maiden name, I have a marriage name, and you're not responsible to put your name that you presently have?
I don't know the law, but I would expect that if a document is in the name of Marilyn Petito and you're now-
Devaney.
I'm saying if it were Marilyn Petito at the time on the document, you might do that because that's the name that was on the document. I don't know the law on that, but it was.
I can tell you as a Realtor, that's not true.
Thank you, Counselor.
That's not true at
Thank
all.
you.
Again,
I'm just saying, look, we base things on fact.
Mhm.
And I think the slanderous things that you are saying about this nominee is despicable. It's egregious. And what, someone does selling $10, selling a house for $10 to someone who is incapacitated. Tell me how you know. Are you his doctor? Are you his spouse? Are you his spouse? Are you a sister, brother, father? You don't know. And you're telling us all of these opinions of why you think she's harassing and all of that. And I'm going to tell you, I've been here 22 years, and I have never heard anyone in opposition give us false information. Never, never. And I follow it up, and I respect these people that come in.
Madam
I
Chair,
really do. So
Madam
I'm
Chair.
just saying that you
Madam Chair.
are, you are out of order completely with your whole.
Hang on, Counselor.
Okay, thank
Are you
you.
wrapped?
I there's nothing
All right.
more to say to him.
Counselor Kennedy.
Yes, thank you. I have a few questions about this. I read through your material.
Mhm.
Okay? Now, I'm not sure that you fully understand the role of a bankruptcy trustee because you refer the bankruptcy trustee as Mr. Harrington's
Thank you.
lawyer.
I don't believe I have.
Well, you
but
did.
but
You
if-
did.
If I made that reference, I will
Okay.
admit that that's an error.
The bankruptcy trustee has a specific role, which really to protect the debtors and divide up the
He
assets.
represents Patrick Curran's estate, is my understanding.
Right. Now, that bankruptcy trustee sued you and your wife, right?
Correct.
For fraud.
I don't recall the exact, but yes.
Yeah, that's what they sued you
Okay,
for, right?
Fine.
How come you didn't attach that with all your other attachments, the copy of the complaint?
No reason.
Don't you think that would have been relevant?
I'm happy to supply that.
Okay. And so you were sued in bankruptcy court
Correct.
by a bankruptcy trustee
Trustee,
who
correct.
alleged you and your wife committed a fraud on the bankruptcy court with respect to this transfer, correct?
Correct.
And you settled it.
Correct.
I don't care how much you settled it for, you settled it.
Correct.
You at least partially, by way of settling, conceded that there was some basis for that complaint.
I disagree.
Well, I disagree with that. You seem like somebody who's somewhat righteous. You're here testifying against your wife's ex-sister-in-law, and you seem like the type of person, if somebody falsely accused you of fraud, you'd defend yourself,
Correct?
but
Absolutely.
you didn't.
Can I address that?
You didn't, right?
Well, no, I'd like to address that, please. What I had,
I'll have another question for you
okay,
in a
thank
minute.
you. I had as our attorney,
Once again, I'll have another question for you in a minute.
okay,
Okay.
one of the top bankruptcy attorneys in the city of Boston. He wrote the book. He literally wrote the book on bankruptcy.
Because there are a lot of people that wrote the book on every law. I hear that
And-
all the time.
And I
I have another question for you.
if I could finish this point.
I have another question for you. You've answered my
Let,
question.
yeah, you answered the
Okay.
question. Let the
Okay.
council continue.
Throughout this, well, let me ask you this. House is upside down, right?
Yes,
Your now wife and her ex-husband went to a divorce proceeding, right? They get divorced.
she had been long divorced, yes.
Yeah. And who was responsible as part of that divorce proceeding to pay the mortgage, the taxes, and all of that stuff?
Both Patrick and Joan Curran were responsible.
That was in the divorce decree?
Yes,
Okay. Was the mortgage paid?
it had some delinquencies.
Okay, it was behind, right?
It was behind in the beginning of 2013.
Okay, well, part of the reason that the house became upside down in terms of what was owed versus its value was because mortgage payments weren't made, right?
No,
Okay. I'd like to see those documents. You can send me those,
sure. I
the
mean,
mortgage documents in terms of when it went into default. Did it go into default? Did you receive default letters? Did you receive, you're a banker, you know what that means.
My recollection, I never saw any default letters, but here's the point. The point is
Can't be
that the
upside
mortgage, the house had been leveraged up before before the divorce, and the market had fallen.
Well, during the time that it leveraged up during the divorce, who was responsible for paying the mortgage?
Well,
I mean,
they were both on the
You
note.
just said I know they're both on the note, but there was a court order. It's my understanding your wife was responsible to pay the mortgage.
That I don't recall the details of the divorce court order.
Okay. Well, if that were a cause of it going upside down, don't you think that would be important for us to know?
It would, but it was not.
But you didn't attach anything related to that.
Okay.
You talk about it being upside down, but you don't say how that happened, who's responsible for it getting upside down, right?
It was largely upside down because of the market.
Now, at the time of this transfer, there was one transfer, as I understand it, correct me if I'm wrong, from Patrick is his first name?
Yes,
Okay, Patrick to your wife for $10. And I get that, he's just getting rid of it, but that doesn't get him off the note of the mortgage, right?
correct.
He's still responsible for it
Correct.
under the law, you know that, you're a banker. So that doesn't do much for him, right? He doesn't get anything out of that. Didn't get any money, didn't get off the note, didn't get off the mortgage.
Until I purchased it.
Okay, until you purchase it. We're gonna get there.
Okay.
Okay? So this transfer happens from Patrick to your wife, right? And at that time, were you married
No,
to her?
No.
Okay, you're not married then,
correct.
okay? And what date did that happen?
I believe it was September of 2012,
Okay, and when did you get married?
December of 2012.
Okay, so you get married within a couple of months.
Correct.
Okay, now, there's a subsequent transfer by way of shots. Did you then buy it from your wife? Or was there a shot sale that occurred?
I bought it from my wife in April of 2013.
Okay, after you were married,
Correct.
okay? You bought the house?
And after we had negotiated with the note holder.
Okay, so obviously, you're a banker. You know how to do that. You know how to negotiate a
I've never
shot.
done it before, but go ahead.
You're familiar with the process.
Not really, but go ahead.
Okay, well, you know people who are, you talk to people, right?
No, I did it all on my own.
Okay, so there's a bank
There was not,
That-
no, it was not a bank.
or a mortgage company, whatever it is.
It wasn't a mortgage company.
was it?
It was an investor group that was like four places down the line that the note had been sold
But-
repeatedly.
Okay,
It was just some group.
it started with the bank,
It's a bank.
It did.
and then it got sold. We know that happens all the time.
Numerous times.
And a lot of times, we're still paying the mortgage to Bank of America, and they don't even own it, right?
If they kept the servicing, yeah.
Yeah, if they didn't keep the service, and it could be some group of lenders from anywhere in the world.
Correct.
Okay, so you negotiated with them,
I did.
okay? Now, and you bought it at a short sale, right?
I bought it at the full appraised value.
That wasn't my question.
Okay.
It was a
wasn't
short,
short-
you know what a short sale, you
I
know
do.
the difference between full appraised value and short sale.
Correct,
You bought it at a short sale, right?
yes.
Okay. And at the time that you bought it at a short sale, did you disclose in writing to those people that you were married to this woman?
I believe I did.
Okay.
Well, hey, wait a minute. What's the question again?
Did you disclose in writing that you were married to this person?
I don't recall a direct disclosure in writing, but everyone
Okay.
was fully
Do
aware of what
you
was,
think that would be important?
I think it was absolutely.
Well, you know that there are a lot of regulations, federal regulations involving mortgages.
I do.
And one of them, and as a banker, you know, it requires full disclosure of everything, right?
There was nothing hidden.
Well, did you disclose it in writing? That's an easy question. It's a yes or no.
I'll say I don't know.
Now, you're talking about all this other thing going on with her. That's a complaint with the Board of Bar Overseers, right?
Yes,
Did you file that?
yes,
Okay. So when you refer to this separate investigation, that's something that you did and you wrote.
correct.
Wasn't from the bankruptcy trustee.
No,
It wasn't from anybody else involved in this except for you, right?
my wife and me.
Your wife and you.
Correct.
Okay, just give me a minute. You didn't attach a copy of your settlement agreement with the trustee. Right?
That's correct. I didn't want to burden you with too much stuff.
Well, we're not burdened. You gave us half the information. It would be nice to have all of it.
Okay, I disagree, but go ahead.
Well, you can disagree all you want. We're the ones that have to make the decision.
I understand
And
that.
when you pick and choose what you give us as opposed to giving us all the information, it makes it suspect. I don't have any other questions. Thank you.
Counselor Jubinville.
Thank you. You file the BBO.
October of 2020.
Year and a half ago,
16 months.
and trustee bankruptcy issue was done? It's over?
Yes,
So this was to get even with what you threw.
no, I'm not looking to get even. I'm looking at a situation that I think is importantly unethical. And frankly, Counselor Kennedy, I understand all of your questions. I don't think they are the least bit germane to what I'm talking about here. And that is someone representing themselves to be another attorney.
You just kind of answered my question.
I'm sorry. if
You were upset with her, you and your wife, because of the bankruptcy proceeding, and she got involved in that. So, right? So you decided
I
to
believe-
file a complaint with the BBO.
I believe that she had done things that were counter to the Code of Professional Responsibility for attorneys in Massachusetts, and I thought she should be called on that.
What was that she did?
Countless things, representing herself as another attorney, coming after us for a consumer debt that she had no business pursuing, interjecting herself. I mean, if you want a copy of the complaint to the BBO, I'm happy to share that, subject to their permission.
We have releases to get anything we want.
I'm
from
sure.
You know, we do our due diligence on this, and we knew about this, so I made my due diligence. And,
Bob, I can't hear you.
oh, I'm sorry, my mic isn't on. Jeez.
What's the downside, Counselor Hurley?
So anyway,
Excuse me, can I just grab my water?
sure.
Thank you.
So would you agree with me that there's been some animosity here since this house was turned over to your wife?
I would say there's been animosity here since fall of 2016, when Mrs. Harrington reached out to my wife with the claims that were unsubstantiable.
So the decision was made by you and your wife that she should receive a complaint to the BBO for what she did.
And it was encouraged by our counsel.
Are you a lawyer? So I researched some cases at the BBO on issues of false letters. There was a case that a lawyer had made up a false letter and signed his name to it, and filed it with that. But anyway, I did some research on that as to what punishment the BBO, if any, would do in a case like this. And the conclusion that I got and I've represented people at the BBO, but the conclusion I got, based on the fact that she didn't deny this to the BBO, she said, I sent this letter. And she's looking at, in my opinion, one of two things: either a dismissal or a private admonition, which is akin to saying, don't do it again. Have you expressed your wishes to the BBO as to what should happen to her?
We have.
And what's that you asked for?
Oh, in terms of what type of, no, that's not my position to do that. But let me, if I can address a point that you made a minute ago. We've also done a ton of research on attorneys misrepresenting themselves in a letter. We have found none of those examples are where the attorney wrote a letter taking on the identity of another attorney. We have seen others where a letter was written, it should have been written, et cetera, et cetera. But I don't believe there's anything out there where an attorney wrote a letter pretending to be another attorney.
Well, let's take the letter. What in the letter is not true, in your opinion?
You want me to go through it line by line? Well, first of all, per the bankruptcy filing itself, it specifically says that the debtor should list transfer of property within 2 years of filing.
2 years or 4 years? I think it
It's
says.
the document, the bankruptcy document says 2, and it says 2 years written out in bold.
Okay.
Okay, so it was in the document that he filed.
Well, this letter says 4 years.
This letter says 4 years, but the bankruptcy document itself says 2.
Okay. So she's wrong in the amount of time you have to file a petition.
I believe that's incorrect, yes.
Okay.
Um,
But that, let me ask you that. You think that's a big deal that you
No.
put 4 rather than 2?
No, but that just caught my eye.
Okay. What else is illegal here or untrue?
Well, the 1, 2, 3, 4, fifth bullet point says Dr. Kern was
1,
never
2,
aware
3,
of the
4.
non-arm's length transaction. It was never given any affidavits or other paperwork to sign relative to the short sale transfer.
Okay, let's just, did you sign any affidavits to anybody indicating that it was a short sale and that you, your wife got it for the $10 and then you got it from her? Did you do any affidavits?
Not to my
Okay.
recollection, no.
So that's correct. You didn't do any.
No, she's saying that he was not aware of it and was never given any affidavits to sign. I don't know if
Right.
that's true or not.
Right. Well, the affidavits would have been from you or your wife. That's what she's referring to, right?
I guess so.
Oh,
Okay.
okay. What else?
Second page, second bullet point. As this was a short sale, the parties to the sale would have been obliged to sign an affidavit, et cetera, et cetera, et cetera. I don't believe that's the case. I've done the research on that as well. I do
Well,
not believe, I
when
do
you-
not believe that there are regulations governing short sales.
Okay,
Well,
well,
very strict
well, let me, well,
regulations.
well.
18
Well,
US code, 13.
Well, according to Fannie Mae guidelines, short sale,
This was not a Fannie Mae mortgage.
okay. They do, but Fannie Mae does say in a short sale that then an affidavit should be given. Right?
Pardon me?
If it was a Fannie Mae, you'd have to do an affidavit, right?
I don't know. My experience is, my entire career has been on the commercial side of banking.
Did you send any writing? Forget the affidavit. Any writing you and your wife signed saying, look, we want to disclose that this happened?
No one asked us to do anything like that.
Okay, so,
Again, Counselor, if I can interrupt you for 1 second. I don't think that anything having to do with the sale of the property is the least bit germane to what Mrs. Harrington did. I don't think at all.
Look, that's your opinion.
Correct.
It's not mine.
Okay.
Before I make a determination on this vote, I want to know everything that happened here.
Okay.
So the second bullet point on the page, the second page says she was obliged to sign an affidavit that the transaction was an arm's length transaction. Is that what she put in there?
That's what's in the letter.
Okay. So let's assume you didn't have to do an affidavit.
Okay.
Do you agree with me that it should have been disclosed to somebody that it wasn't an arm's length?
No, I don't.
Okay. So aside from that paragraph, what else is wrong in the letter?
Other than the fact that it was written by Sheila Harrington in the voice of Attorney Casey.
No, I get that. I
It's
get,
not speculation
no,
at
no,
all.
no, whoa, please. Please. I read the letter. I know what you're referring to. She made it appear it was to her. The letter was to her, right?
Correct,
Okay. From a law office.
correct.
She doesn't say Casey's name in this thing at all, does she?
She says, as you are aware, your
Mm-hmm.
brother, Dr. Patrick Curran, has sought the services of our office with respect to the filing of a Chapter 7 bankruptcy.
Okay.
That could only be one person, and
Okay.
that's Attorney Robert
Okay.
Casey. And then she closes by saying, as you referred your brother to me, that could only be one person, Attorney Robert Casey.
Well, from me reading it, how do I get that?
It's a simple deduction that Robert Casey was his attorney.
Right?
This is written to
Okay.
Dear Attorney Harrington.
Yeah. I get it.
Okay, and my
I
attorney.
get it. I get the letter. Other than those two issues we spoke of, what in the letter is false?
I don't believe that's the least bit germane to what we're talking about.
I didn't ask you that. I asked you
I-
to
I-
tell me on the letter, since you sent this letter to the BBO, and it's part of the complaint, what on the letter is false, other than she said you need an affidavit, so let's give it that you don't need an affidavit. Is that really the biggest deal here?
I frankly don't, I don't have time to go through everything here in front of you, but I don't believe that everything in here is
We have
factual.
plenty of time.
Well, what isn't factual? The affidavit, well, I give you that. The affidavit in the first page too. Okay. So you didn't need an affidavit. What else did she say in here that is false?
She says that he did not convey the interest in the property for fair market value. The
Well-
fair market value was a negative number.
Well,
And
well,
frankly,
whoa.
go ahead.
I'm not a real estate attorney. I'm not an expert in real estate. Aside from the mortgage, let's assume there was no mortgage on it. What was the house worth?
When I first had it appraised, it was appraised at $450,000.
Okay.
And then when I went to purchase it, the bank appraised it at $475,000
Okay. So it was underwater with regard to the mortgage.
completely.
But aside from that, it was still worth more than $10, wasn't it?
His interest in that property was not worth even $10, no.
He couldn't pay the mortgage.
But
And your wife didn't pay the mortgage either, did she?
she did not make payments after the first of the year in 2013.
Okay. And her ex-husband was suffering from a severe case of alcoholism, right?
I can't speak to that.
You never heard that?
I've heard all kinds of things, but
Well,
I've.
Wouldn't your
my
wife
interac-
say, wouldn't your wife say to you that
I'm
he's got
I'm
this
just saying,
disease?
I don't want to give you an opinion. My point is that my interactions with Patrick Curran from the time I met my wife until today have been extremely limited. I cannot tell you about his health or anything related to that.
Okay.
I don't know.
Okay. So, in the letter, the only thing she says, according to you, that's wrong is the affidavit issue. Right? Basically, everything else is what happened in this case. Oh, and the 4 years is instead of 2 years. Right.
I don't want to say yes because I don't have time to go through this piece by piece.
Well,
but
listen.
Go ahead.
This isn't the first time you read this letter.
I haven't actually read it in a number of years, probably.
Well, you certainly read it a bunch of times after.
I've gone through it in
Right.
past years.
In fact, you thought so much of it, you made sure the BVO got it.
Yep.
Right? So you're familiar with it.
Mhm.
You're more familiar with it than I am, or we are, right?
Yes.
Okay. So,
There's one piece in particular that I'm not seeing in here that has been alleged in the past. And I just want to see if it's in here where it might not be in this letter, but it might have been in the other filing wherein Sheila Harrington suggested we hid our marriage from the other parties in the transaction, and that is absolute falsehood. I have a letter that I sent to the attorney, I'm sorry, to the Attorney General's office in the Commonwealth while I was in the middle of negotiating on behalf of my wife and on behalf of Patrick Curran, which he signed off on to negotiate the sale of the home. And I wrote to the Attorney General's office because I wasn't getting a lot of feedback from the note holder and the loan servicing entity. And in that letter, as in other letters that were written to the loan servicing entity and the mortgage holder, everything was disclosed about who was who and when was when, and everything having to do with my wife and our marriage and everything there, related to that.
okay. Well, when I look at the documents, and I think whoever looks at the documents and what happened here in this case, when the house was sold for the $10,
I think that's not Patrick Curran's interest in the property was transferred for $10. The house was not sold
Yeah, it
for
was.
$10.
well,
His
the-
interest
Yeah, it
in the-
was.
well, was a deed given?
Yeah,
Well, isn't that proof of a
he,
transfer?
right, but I'm saying his
I'm-
interest in the property.
I'm
not-
using the wrong word, a transfer.
Right, but his interest in the property was transferred.
Right.
We didn't buy the house from him for $10. My wife didn't buy the house from him for $10.
She got a deed from him
She got a deed
for
conveying
$10.
his interest in the property.
For $10.
Correct.
So the deed says $10.
And as an attorney, I'm sure you've seen 1,000 documents where things are transferred for $1.
I have.
Right.
Well, I know of it, yeah.
Yeah.
So, but the deed says $10. So you're kind of splitting hairs with me on this,
Well,
right?
Isn't that what the law's all about?
No,
You know.
Go ahead.
no. You got a deed and it says $10 on it. A
So
deed
it
says the
does.
price of the house, doesn't it?
Yes,
Transfer.
yes, it does.
Okay. So as I look at it, if I didn't know you sent a letter to the AG's office explaining that it was your wife, I would think that the deal was done, short sale, transferred to her, short sale, you end up with it. Would you at least agree with me that somebody looking at it outside of the letters you sent to the AG's office might say, what went on here?
If someone didn't have all the facts, I'm
Right.
sure that they could ask
Right.
all kinds of questions.
Who's Patrick Padden Jr.?
That's me.
Oh. And do you have a son too?
I do.
And was he involved in this?
No.
Okay. Were you the one that was gonna do her brother's interest and represent him as far as finances went or anything?
So that's been alleged. That never took place.
It didn't.
But I also have a stepson named Patrick.
Was he involved in it?
Involved in what?
In this issue we're talking
No,
about?
with the transfer of the property?
No. Taking care of her brother's finances.
A little bit, yeah. Yes, when he was hospitalized.
So,
But I had never had anything to do with anything related to Patrick Kern's finances, ever. Nor did I ever
no,
suggest
your
that.
son did.
No. My stepson,
Your stepson did.
correct. My stepson went on his father's checking account when he was hospitalized to try to help him keep some of his financial affairs in order.
So you mentioned that she had committed illegal acts. Tell me what act she committed that are illegal according to general laws of the Commonwealth of
I'll
Massachusetts.
just say illegal in terms of the federal bankruptcy law, where she contacted us
Mhm.
and said specifically, only deal with me in this matter. Well, that's not who's representing his interest at that time.
Tell me the chapter and section of that law.
I don't know that.
She contacted the trustee, right?
On more than a few occasions.
And the letter, the item that says, just deal with me, who is that directed to?
My wife,
And you say that that's illegal.
for her to reach out to my wife
Mhm.
saying that, setting forth things that are involved with the bankruptcy court and says, only deal with me. Yes, that's illegal. And per my attorney,
Why?
because Patrick Kern's interests at that point in time were represented by
By
the
trustee.
trustee. The trustee is the only one who can deal with his interests,
Well,
per my
The-
attorney.
the trustee received something from Ms. Harrington, right?
I don't know, I don't
Well,
understand.
she got involved with the trustee, didn't she? You said she talked to the trustee. There's
yeah.
a bill for her
In
talking.
numerous occasions, yes.
Well, the trustee didn't tell her not to call her, did she? Or him?
The trustee didn't,
Didn't say, yeah, I can't talk to you. To her.
I don't know. How could I be privy to that?
But she did listen to her, didn't she? She conducted more of an investigation, didn't she, based on what she was told? And it cost you money.
Apparently, yes.
So the trustee didn't say, hey, I don't want to hear from you, Miss Harrington. You got nothing to do with this. The trustee listened to her and did some action after that, didn't she?
Apparently, yes.
Yeah,
For years.
yeah. So the trustee evidently didn't think it was improper.
The trustee at that point didn't know that Mrs. Harrington had reached out to us and asked us to only deal with her.
Okay, but you didn't do that.
Didn't do,
You didn't only deal with Miss Harrington.
no,
You ignored that.
absolutely.
Okay. So no harm was done on that. You ignored it.
But that was nonetheless a violation of the automatic stay in the federal bankruptcy law.
Okay. But my point is the trustee listened to Miss Harrington and took action based on what she said.
Based on what she said, not
Right.
based on what they had discerned from all the filings up until that point.
Do you agree with me that the trustee has a duty to do that?
Trustee has to follow up on something like that?
Sure.
Mhm.
On some sort of an allegation about a sale?
Sure.
That's what the trustee did. And you're saying to us here a little while ago that it cost you and your wife some money.
Yes.
And you blame her.
Yes.
Why don't you
Absolutely.
blame the trustee?
Because nothing was happening with this at all.
Well, why didn't you say to the trustee, why are you
We
billing
did,
me?
and I'll give you the exact wording that was given to me
Yeah.
when it came down to, look, here's where we stand on this thing. We can take this thing to trial and you will win, I was told,
You would win.
right before we settled.
Okay.
My attorney said, you will win on this. However, it will cost you more to pursue this than what the trustee is willing to settle for. And like I say in the package and in my remarks this morning, the trustee settled for barely anything over her expenses.
I'm talking
And-
about the trustee taking information from Ms. Harrington and going and investigating that.
Correct.
And that was the duty of the trustee,
Oh, if you,
right?
if you say so, yes.
Well,
And my point is,
Do you disagree with me on that?
no, I do not, but there was
Okay,
nothing
so
there.
don't say I said so. You're agreeing with me,
Fine, thank you. I
right?
do, yes.
Okay. But yet you're saying it cost you a lot of money and you're blaming her for it.
Because there was nothing there, and I was told by my counsel that this is, quote, and I quote, legal extortion. The trustee knows it'll cost you more to try the case than to write her a check.
Okay.
And so she settled for, like I said, barely more than her expenses. And there had been nothing prior to Mrs. Harrington's involvement in this situation.
So,
Discerned by the trustee or the trustee's counsel that there was anything.
well,
untoward.
it seems to me that the animosity here goes back a long way. And it probably survived all through the bankruptcy, the animosity between you and your wife and Miss Harrington.
As I said, I've
Correct.
never met Mrs. Harrington.
You had animosity towards her, didn't you?
If anyone comes after.
No. My
family,
question is,
shake
my question is, you had animosity towards her, right?
Yes,
Whether you met her or not.
yes.
So with that animosity, and you could have won the case, well, I'm going to settle the case. I'm going to agree that we're going to settle it.
Correct,
We're not going to go forward here.
correct,
Your lawyer says you can win it.
correct.
Well, I don't know how lawyers can make that call, quite frankly.
Experience.
You know, I've been a lawyer 44 years. I can never tell a client, you're going to win this trial that we're going to have. I can't ever say that, even if I think he's got a damn good case. Because I don't know what a judge is going to rule in the end or what a jury's going to do, right?
I understand that.
So
I'm
the
just-
best I can say is, yeah, you got a pretty good case here, but you take it, when you go to trial, you take a chance. You never know how it's going to come out. Right?
I agree.
Okay, so you didn't want to take the chance.
No, that's not the case.
Okay. Well, now it's about money. You didn't want to pay the money.
I didn't want to pay anything. And I would never have wanted to deal with this whole situation for the last 5+ years either.
Well,
And.
well,
the
sir,
only
sir,
reason-
sir,
Go ahead.
sir. For somebody who didn't want to deal with this thing, you have certainly continued to get it going by going against her at the BBO.
I
Right.
agree. Yes,
So you're keeping this thing going.
because we've been wronged.
You've been wronged.
Correct.
You've been accused of a short sale and a non-arm's length deal, and
Correct.
that's a wrong you're suffering,
Correct.
right? Well, I have to tell you, I don't understand sometimes that this animosity can go and end up here at the governor's council after all these years. I don't even know why it's at the BBO, and maybe I'm different than you. But if it's me, I go, you know, we went through a lot. It's over. You know, I don't want anything to do with her. I don't want to get involved in any other proceedings because that takes something out of me.
Yeah.
So not with you, though. You're beating the drum to make sure she doesn't get this job. You're beating the drum to make sure she gets disbarred. And you're keeping it going, aren't you?
We've been wronged. And if
Sir,
somebody comes after
sir.
my family, I'm going to follow up on that.
And she came after your family by saying that she
By
thought,
accusing us of fraud.
You were found guilty
Okay.
of fraud.
No, we were not found guilty of anything.
well, you settled a case for fraud rather than try it.
Correct.
Okay. So did the accusation, well, your opinion, you got accused of fraud. What did that do to you? Did you lose your job over it? Did you and your wife have a divorce over it?
Nope.
Then I guess I don't understand the revenge component here.
Nor do I understand the revenge or the vengeance
Okay,
that initiated everything.
let's assume you don't understand that. Okay. But you seem like a very intelligent man.
Thank you.
You work at a bank,
Yes,
a lot of responsibility.
yes.
I just don't understand why, people have wronged me, and I'm sure people have wronged everybody in this room at some point in time. But most people don't say, I'm going to get even, no matter what it takes. I'll take time. I'll go to the BBO. I'll write this big packet up for the governor's council. I'll sit there and I want my pound of flesh. Right?
No, what I would say is if someone accuses me and a family member of fraud and things along those lines.
Yeah.
And then costs me a lot of money for no other reason than for her to exert some level of vengeance against my wife,
What?
then I'm not going to take that lying down. That's what I said.
You're never going to let it go.
I didn't say that. I'm just saying, I'm not going to take it lying.
When are you going to let it go?
I don't know.
Well,
I think
how much money, you're saying money because of the trustees' expenses?
in legal fees.
Okay. Did you say anything to the trustee or sue the trustee for taking a claim that was frivolous?
It's been advised to me that when these matters settle, that it may well be worth our while to reopen the bankruptcy case.
And you're probably going to do that.
I don't know.
Well, you're sitting here with a grudge.
No, it's not a grudge, sir.
It's like revenge. I'm
It is
getting
not-
even at all costs
No.
here. You just told me that.
No, I'm not telling you that at all.
just told
What
me.
I'm telling you is I'm defending myself
From what?
from baseless claims against me and my wife
They were made how long ago?
5 years ago.
Did she put it on the internet? Did she put a sign up in front of your bank that you're a fraud?
It's in,
Come
it's,
on.
Oh, come on.
We
Stop.
have to, I have the ambassador with me.
The what?
Ambassador.
Oh, okay. Sir, I thank you for presenting what you presented. I don't get
and,
the get even here.
and I appreciate your time. And like I said earlier, I don't take this lightly in any way, shape or form.
I agree with you.
But
I
nor
have
do I
questions.
understand. You don't understand
And then go back.
where I'm coming from. I don't
No, I do.
understand. I don't understand how this body or any other body can just gloss over the fact that Mrs. Harrington assumed the identity of another attorney in an attempt to
We're
extort
not
money.
taking that lightly.
Okay,
If you say,
but I really want to get him.
We're not taking that lightly.
Thank you.
But, we weigh the whole evidence here and
That's-
that was a mistake she made. There's no doubt about that. It didn't hurt you.
it absolutely hurt me.
All right, we're gonna,
Okay,
I
thank
want you to stay there because we'll continue with you, but right now we have the ambassador from Ireland on, from Dublin. Thank you, Ambassador Cronin. You're my emerged sister, so it's wonderful to see you. Can you hear us?
Oh,
Yeah.
here.
Yeah,
Can't hear you.
we can't hear you. Hang on.
There's a leprechaun over there shutting us off.
You got your audio?
Now I have
We've
my.
got your audio. Thank
I'm-
you, Ambassador. We know you just arrived yesterday, and so we greatly appreciate your time, and we look forward to your testimony.
Thank you so much. In fact, I arrived this morning, so I'm still
God bless you.
operating with no sleep and just finished
Well,
my,
I'll be there to visit tomorrow.
what was that? I just finished.
Gonna visit.
I know you have a lot of people saying they're going to come visit you, and Terry Kennedy just put himself on the list.
Me too. Yeah, you have a lot of friends when you have a spot in Dublin for sure. So I just returned from the embassy back to our new home in Dublin. And I previously thought this hearing was going to be last week before I left. So I apologize that I couldn't be there in person, but I am delighted to testify before you today. So Chairman Duff and members of the council, I am here today in Dublin to support Governor Baker's nominee for Clerk Magistrate of the Gardner District Court. It has been my honor to serve in the House of Representatives with Sheila Harrington for 9 years. But within those 9 years, Most specifically, we served for 9 years together on the Judiciary Committee. I served for 1 year, 1 session as vice chair, and 2 sessions as the chair of the committee. And Sheila was the ranking minority member of the committee. As I know you are aware, the Judiciary Committee handles the largest volume of bills of any committee in the legislature, and often the bills that are considered the most controversial. The Judiciary Committee also deals with all issues surrounding our court system. Sheila Harrington was certainly one of the hardest working members of this committee. She was always prepared, always engaged, and always present. In our hearings, Sheila demonstrated a wide breadth of knowledge of all areas of the law, not just her area of practice. And I was always really impressed by that. She was very well versed in both statutory and case law. One of the critical areas that I spent a lot of time working with Sheila individually on was when we passed criminal justice reform in 2018. And Sheila served on the conference committee that reconciled the House and Senate versions of the criminal justice reform legislation. We worked together for months, and Sheila's contributions were instrumental in getting a bill to the governor's desk for signing. She demonstrated a strong work ethic, great listening skills, and always an ability to understand opposing views. In addition to that, she was able to process the differences and work to resolve the differences by way of workable and creative solutions. I greatly admire her skill set, and she has always been a pleasure to work with. As you must know, I am a Democrat and Sheila is a Republican, but despite our party differences, our work together became the basis of a wonderful friendship. And I consider myself lucky to have Sheila for a friend. She is a devoted wife and mother. She is intelligent, kind, and respectful to others. All people, doesn't matter who you are, if you are the humblest of human beings, or if you were the President of the United States, she treats everyone equally and with great respect. She's extremely well liked and well respected by our House colleagues. And if she is confirmed by your Governor's Council, it will be a great loss to the House. And I know it will be a great loss to the people of her district because she has worked so tirelessly on behalf of the people she represents. In going forward, I've always viewed that a clerk magistrate, like a judge, should have what I call great or excellent judicial temperament. And Sheila possesses all of those qualities. As I said before, she treats all people with respect and dignity. She is patient, she is fair, and she is logical. Also importantly, Sheila understands the human condition and how life circumstances can contribute to situations that often land people in our court system. She understands that human condition, but she also has a great understanding of the inner workings of the court system. She's well versed in the law, both civil and criminal, and I have seen that through the work on the many pieces of legislation that we have worked on. She has another great qualification that I think is important. Sheila has great common sense. And I think that that's something that every clerk magistrate should possess. But most of all, Sheila is a person of great principle, and her integrity is without question. She would be an outstanding clerk magistrate and would serve the court system and the people it serves well. So I recommend her to you without reservation. And if you so desire, I am happy to answer any questions you might have about her candidacy.
Thank you,
Thank-
Ambassador. To any, oh,
I do.
Counselor Devaney.
Thank you. First of all, Ambassador, I want to congratulate you. We're so proud of you. And I was so honored to be in the House to hear your final farewell speech. It was so heartfelt. Thank you for doing this. You must have a little jet lag.
I think I have a
Now,
lot.
no, I'm thinking of, that Sheila was on the Judicial Committee, but also, could you tell us what criminal legislation that she championed that was important to you?
Sure. Well, I think that would be, hard to say any specific piece. As you know, in 2018, we enacted an omnibus criminal justice reform bill that covered every aspect of our criminal justice system, from the time someone might first intersect with the criminal justice system, and that would potentially be as a juvenile, or as a child that is a child in need of services involved with DCF. And we took and made revisions every step of the way, whether it dealt with when you're first involved with the system, our juvenile court system, things surrounding trials, probation, parole, from the beginning to the end of someone's time or their involvement in the system, whether it be when they are at the end actually released by compassionate medical release, or whether they return from incarceration and re-enter their neighborhoods. So within this bill, we covered it all. And on every step of the way, Sheila was there, and she always brought a very logical, just great approach to any differences we had among the committee. And certainly there were some. We had some versions, there are some people that would want to eliminate all crimes or eliminate all mandatory minimum sentences. And there were some people that said, no, that maybe we want to do drug offenses that are, more closely associated with the use or substance abuse of drugs, people to not get a mandatory on that. But then when it comes to something like trafficking, and maybe we don't want to eliminate them in those cases. And so as we went through this process, Sheila was a part of it every step of the way. That Criminal Justice Reform Committee worked, for several months trying to reconcile the bills, because there were differences between the House and Senate bill, and we were able to. But I would also say that before we even got to the point of passing a bill, Sheila attended every hearing. And when those criminal justice hearings they went sometimes up until midnight, 12-hour hearings. And Sheila is always the one that no matter how late it would get in a hearing, she wouldn't leave to go home early. And she would stay and she would ask very thought-provoking questions, very intelligent questions, and just had a really great understanding of all aspects of it. And at the time, I remember being actually surprised that someone that spent a lot of their time in the probate courts would have such a great working knowledge of this. So I was just incredibly impressed by her hard work on that.
Well, thank you so much. I have to tell you, you are the first ambassador to be a witness for any nominee. So, but I want to tell you that your testimony really means a lot, and I've been following you for years, and I mean it from the bottom of my heart. You will be missed. You have done so much in judicial and in criminal reform, and thank you. And I wish you all success and happiness in your new role. Thank you.
Thank you,
Thank
Counselor. Counselor Jubinville, and then Counselor Fiara.
Thank you.
Congratulations, Ms. Ambassador.
Thank
Uh,
you.
We're going to miss you on the Judiciary Committee. You were our court savior on the Judiciary Committee. So
I didn't
wish.
do it alone. I did
No, you
not do
didn't,
it
but
alone.
you were an advocate for the downtrodden in the district court system and the superior court system, and we're going to miss you. And being a citizen of Ireland and having an Irish passport, I've been to Ireland many times, and I hope to get over there when you're there and say hi to you.
I hope to see you if you fly across.
Thank you. Council Fiera.
Thank you, Ambassador. I just want to say thank you for your service to the Commonwealth. Congratulations. I've also heard from our friend Representative Fiola about the nominee and Representative Haddad about the nominee. So she's in good company with all these great support stories, and I certainly appreciate the time you took today to speak to us.
Thank you. And as I say, because I have such faith and confidence in Sheila, I made every effort to do so, because if she is confirmed, I think it will be a great benefit to our system and to the people our court system serves. And it is about service, and Sheila Harrington is the consummate public servant.
That's what I hear from a lot of people.
Thank you. Any other councilors? Thank you very much, Ambassador. Thank you for taking the time. Go
Thank
have
you.
a pint and get some rest.
I think I'll get some rest.
Good,
Take
good
care.
idea. Thank you.
Thank you so much. Bye-bye.
Thank you.
Just let me finish up.
Council Jubenville will
Just let me
continue
fin-
his
I just have a little
questioning.
more for you.
Sure.
The letter was received by you or your wife when?
October 17th of 2016.
Okay, thank
I read the letter and I get the fact that she is saying that some things happened that shouldn't have happened, right? Her opinion is that there was some skullduggery going on here.
That was her opinion, yes.
Right. Where else did the letter go other than to you?
My attorney?
Did she send it to them?
No, I did.
Okay.
I provided that to my
Yeah.
attorney, absolutely.
And you provided it to BBO?
Correct.
Okay. Where else did it go?
No place to my knowledge.
Okay. So I look at this letter and I say, well, if I got the letter, yeah, I don't like the letter. Shouldn't have been written, but I throw it in the waste paper basket because I'd say it's garbage. It's not doing anything to me. The sale was fine,
Agreed on all points.
but you didn't do that.
No, we kept it. And then in the spring of 2017, we got a letter from Attorney Alex Matera, who was trustees counsel, suggesting that all of these wrongdoings had taken place, and they had not.
Well, who brought it to their attention?
Who's?
The other attorney. Who is the other attorney for? Medeiros or somebody you just mentioned?
Matera, he was trustees counsel.
Okay. So who gave him the letter?
I don't know that he ever saw the letter.
Okay. So what I'm saying to you is, it didn't seem to do much to you. There wasn't really any serious misrepresentations in it. It laid out what had happened. The suggestion is that it wasn't right.
The letter itself is a misrepresentation.
Right. It said it wasn't right.
And I'll point out one other thing, Counselor. In Mrs. Harrington's answer to the other matter that's going on,
Mhm.
she provided a memo. And if I don't have it with me, but it was memo short sale 64 Summer Street, something along those lines. If you looked at that memo side by side with this letter, they're almost identical.
Okay. But she signed that.
No, she didn't.
At
What
the
I'm
BBO?
suggesting,
She signed her answer to the BB.
she certainly did. My point is this: if she had sent that memo to us, it might have been a different situation. But instead, she took that letter and she took that memo and converted it into a letter that is wherein she assumed the identity of another attorney with the idea of intimidating and harassing my wife. The first thing that we saw when when that letter came into into my wife's email, she showed it to me. And frankly, the first thing I said was, wait a second, this doesn't make any sense. There's no letterhead. It's not signed. Something's fishy here. And it wasn't until years later,
And it wasn't true, according to you.
what was, no,
The stuff.
right. The point being, it wasn't until years later when light went off in my head and said, wait a second, this is a Word document that she
I
sent.
know.
If it had been a PDF, I'd still be out to sea on this, but it was a Word document. And I opened up the
I
document
get
and
that.
I see that it was
get that.
written by Sheila Harrington.
I
So
get that.
let me
She's
just finish.
taken ownership of it.
My point is this, you said a few minutes ago, before the ambassador spoke, you said she made a mistake.
Yeah.
I don't think it was a mistake at all. I think it was an absolute deliberate attempt to color her research under the guise of it being submitted and written to her
Yeah,
by another attorney.
I get it.
That's not a mistake. That's malfeasance.
Well, yeah, it shouldn't have been done. We make mistakes intentionally sometimes that we then say, well, we should have done it.
We all make mistakes.
Right.
This is a big one.
But this did nothing to you,
It absolutely did.
other than to bruise your ego.
No, sir.
Period.
No, sir.
And because of that, you're still living with this every day, trying to injure her to get even with her.
You asked me earlier.
I'll tell you, your animosity, I suggest to you, you should let it go because it's making you appear to be very vicious and vindictive.
I'd like to ask you a question, if I may.
You can ask me a question.
Based on the fact that first of all, I don't believe that the transaction regarding the sale of the home is the least bit
I
germane.
get
to what
it,
I'm
yeah,
here for.
I get it.
Based on the fact that the house was underwater, what's the benefit to Sheila Harrington of coming after us 3 years, more than 3 years after the house was sold? And when she did, she submitted in that email a 2016 valuation of the home and suggested that we owed money.
So,
It was not
in
germane.
your opinion, it wasn't right? Your opinion, it wasn't germane.
Correct.
Well, so what?
So
I'm telling you, sir, you are coming across here as mean and vindictive. This is eating you away, and I would suggest, I don't know your wife, but it's probably the subject of conversation in your house many times. And you're gonna keep it going to try to punish her no matter how far you have to go with this.
And if someone had accused you of fraud and cost you significant amount of money, wouldn't that eat at you for a while too?
A short while. I hope,
Well,
because when you carry it around with you, it ruins you.
this went on for years because of the.
And if you
trustee-
had thrown that letter in the bucket in the first place, we wouldn't even been talking about it.
I disagree, because Alex Matera would have got that letter, and he pursued it based on those allegations.
Sir, you're coming across as mean and vindictive, I can tell you that. And I feel sorry for you. Because it's tough to carry that around. Thank you, Madam Chairman.
Thank you. Counsel Hurley? Can you hear me?
Yes, thank you. I'm trying to follow along with all the exhibits and everything and all that's going on. So, let me see if I can put this in perspective. You married Sheila Harrington's ex-sister-in-law, correct?
Correct.
Who was married to Sheila Harrington's brother.
Correct. Excuse me, correct.
They went through a divorce. And I'm gathering that somehow or other, the home was dealt with in the divorce. Is that correct?
Yes.
And who got the house in the divorce?
It stayed in both names.
And who got the right to live there?
My wife.
All right. And was there anything said about the obligation to pay the mortgage?
I'm sure there was. I've not read the divorce documentation.
All right. So as part of the divorce, he had to pay child support, is that correct?
And alimony.
And alimony. And did she have to pay the mortgage?
But I believe, yes, she was paying the mortgage out of the alimony.
Okay. And at some point, did the alimony or the child support cease?
In December of 2012, when we, well, the alimony ended in December of 2012 when we got married. The child support ended in May of 2018 when my youngest stepchild graduated from college.
All right. So going back to the mortgage and the house, at the time that he signed a deed for $10, it was $10 consideration, like many times you'll see deeds in the registry of deeds for $1 and other valuable consideration.
Agreed.
At that time, was there any equity in that home?
No,
And was it your wife's and your intention, once you got married, to basically attempt to negotiate with the mortgage holders to have a resolution of the mortgage and a release of any further obligations to pay that mortgage because the property was underwater?
yes, and if I can give you a little detail there, ma'am. We got engaged in, well, we'd been engaged for a while, but it wasn't until August of 2012 that we set a wedding date, and that was for December of 2012. Based on the fact that we had set the date, the first thing I did was I reached out to an appraiser to get an appraisal for the property so we could get that piece of the puzzle solved. And I can remember like it was yesterday when we got that appraisal and realized that the property was significantly underwater.
And that was for purposes of doing prenups or
No,
deciding to live in that house?
correct. Deciding to stay in that house.
All right. So at some point, your wife contacted her ex-husband before you got married or after you got married?
Wait a minute. Before he got remarried or before we got married?
Before you got remarried, before you got married?
Yes. Right away, she reached out to her husband and her ex-husband and said, look, we just had an appraisal done on the property. It's significantly underwater. Do you want the house? And he responded, no, I don't. And I couldn't if I wanted to because I'm not working now.
And as a result of that, she indicated that she would take the house for no value if he would sign a deed, and then she would negotiate with the lenders to try and resolve the fact that the house was substantially underwater. Is that correct?
With one exception, ma'am, I reached out to the lenders and in an attempt to handle those negotiations. And one of the first things they said to me was, you're not a party to this. We would need something from Patrick Curran allowing you to negotiate on his behalf. So we prepared that and sent that off to them. And then starting in September of 2012, I negotiated with the mortgage holder through the servicing entity.
All right. So at some point in time, was it before or after you resolved the issue with the lending authorities that you got a deed from Mr. Curran?
Before.
So you had the deed before you negotiated, and that deed was from Patrick Curran to Joan Curran. Had.
No, it was from Patrick and Joan to Joan Curran. She was still using her former married name. We were not married.
All right. So the fact that the deed was in the name of Joan Curran was what the name that she was known by, correct?
Correct. Absolutely.
And then you got married and negotiated with the lending authorities to forgive some of the debt on the house
Correct.
in consideration of you paying a lump sum for the value of the mortgage.
The full appraised value for the property, yes.
All right, which was less than the value of the mortgage.
Correct.
Thus, it was underwater.
Yes.
So that was in 2012, 2013.
Yes.
This letter that was written by Sheila Harrington, I guess there was text initially.
Correct.
I saw the text in the exhibits. That was started when?
October of 2016.
And Patrick Curran filed his bankruptcy in 13?
No, he filed Chapter 13 in November of 2015. It was almost immediately converted to a Chapter 7 in December of 15. And he was discharged from all his obligations in April of 16.
All right. And so the bankruptcy, in a bankruptcy, having represented several entities and people as it relates to that, the purpose of a bankruptcy, when you file for bankruptcy, you have to list all your assets, correct?
Yes.
And you have to list all your debts,
Correct.
secured or unsecured.
Yes, ma'am.
So at that time, he did not list the house. I don't recall seeing the address of the house.
He
But he never-
did not. Go
He
ahead.
never listed the house as an asset,
That's correct.
nor did he list it as a debt because that debt had been discharged. Is that correct?
That's correct.
Okay.
This was the filing of the bankruptcy was more than 2.5 years after the transfer of the property.
All right. So all of a sudden, this texting and emails, and then this letter that perceivably was written not by Mr. Casey, but by Attorney Sheila Harrington, precipitates the trustee getting involved and your wife being put on notice that there was some kind of accusation of fraud. Is that correct?
The accusation was against the two of us. But yes, it's
Okay.
correct.
All right. So then the trustee is contacted by Sheila Harrington, and your assertion is that some pressure was put on the trustee in part due to her being a state representative. Is that correct?
Yes.
All right. And so the trustee notifies you, you have to hire an attorney. Is that correct?
That's correct.
And you hired not just one, but two different attorneys?
Initially, we hired a gentleman from Salem, and then later we hired Alan Bronstein from Boston.
So,
So there was only one at a time.
all right. But they dealt with the trustee,
Correct.
and the trustee investigated and saw the appraisal on the house and what the value of the house was and what the amount of the mortgage was. Is that correct?
I assume so.
All right, and in negotiations to try and resolve this, you paid a nominal sum, correct?
As my attorney refers to it as a nuisance sum. Yes.
All right, so settlement for nuisance value. Insurance companies do it all the time.
Yep.
Here's the $64,000 question, sir. What did it cost you for your attorney's fees, plus the settlement with the trustee? How many thousands of dollars did it cost you?
25 to 30,000.
And your complaint with the BBO, Board of Bar Overseers, you were asking that those costs be reimbursed to you. Is that correct?
Yeah, we mentioned that in there because I don't know how the process works, but yeah, we'd love to get them our money back. Absolutely.
All right. And are you here today because of the money? Or are you here today because of what you feel was inappropriate conduct on the part of Attorney Harrington?
All of the above.
Is it fair to say that if you hadn't had to expend all that money and if you had not been accused of fraud, you probably would not have been here today?
I might put them in the reverse order, but yes, that's a fair statement.
All right. And when did you file with the Board of Bar Overseers?
October 2020.
All right. So was there ever a hearing on this?
Not yet.
All right. And if Attorney Harrington was willing to pay you the 25 or 30,000 with substantiation of the exact amount, would you withdraw your objection here today?
Frankly, ma'am, if Attorney Harrington were willing to make us whole and enter into a stipulation that she would not have any further contact forever with anybody in my family, I would certainly give that very, very serious consideration.
All right. Thank you, sir.
Thank you.
Thank you, Counselor Hurley. Counselor Devaney.
Thank you. I just wanted to follow up and recap what you said. Misstatements, okay? First of all, just to recap, this is Patrick Curran, Dr. Curran, who was your wife's ex-husband.
Yes.
And he sold the house, $10 to your wife, and this was 4 months after you married her. Now,
No.
when I said he
No, it
was,
was not 4 months after we married.
huh?
It was not 4 months after we married.
What was it then?
He conveyed his interest in the house to Joan approximately 3 months before we were married.
That's right. That's right.
Okay, so you were married.
No,
You weren't married.
when he conveyed his interest, no, we were not.
All right. Okay. All right. Let that go. That's not the misstatement that I'm saying about you. First of all, when I said that Dr. Curran was incapacitated, depression, alcohol, addicted, you said, that's not true. We've got that on the tape. You said, that's not true. Now,
I think I said, I don't.
I'm reading a letter.
I said, I don't.
I'm
know.
reading a letter from Dr. Curran's lawyer. And he said, Dr. Curran has no recollection of even signing the deed in the presence of a notary in September of 2012. And that the next week he was hospitalized in McLean's hospital. I think that's documented that the man was incapacitated. He did not know any of that. He wasn't given any documentation when he signed that. And I mean, it just, to me, it is so unbelievable that just duty of vindictiveness, you
No.
want to prevent this
No.
qualified person
With-
from being on the bench. And it's all your opinion.
No,
You don't
no.
document it.
With
How
all-
can you say a man that was hospitalized at McLean's was not incapacitated, that he knew that he sold it for $10? There wasn't any affidavit, no paperwork to sign, nothing. He signed nothing, and he doesn't have any recollection of it. But you say he's fine. He was in good health,
No,
right?
I didn't say that, but more importantly, ma'am, and with all due respect, you just referenced the letter from Dr. Curran's attorney, right?
That's true.
No, that's the letter that Mrs. Harrington wrote. That is not the letter from his attorney.
How do you know that? How can you say that? You
Because
just told us, you just told the council here that you would tell the truth and nothing but the truth.
Absolutely, this is the God
Really?
honest truth. Because if you look at Exhibit F, that is the screenshot from that document that shows that the document entitled Casey Letter Recurrent Bankruptcy was last modified on 10/17/2016 and created on 10/17 of 2016 by Sheila Harrington. That's right off of the document itself. I said this earlier, had Mrs. Harrington sent this as a PDF document, we'd have not known. But she sent it as a Word document, and any Word document you have.
Well, let me just say this, okay? We'll be hearing Sheila Harrington's presentation, and she will address all of these false accusations because they are. I mean, how,
Right, ma'am.
just saying about this man who had physical and mental issues knew that he was selling a house for $10. And it's fraudulent, and it's going to be proven it's illegal that you did it, that she did it to a spouse. It's illegal. I know that. So you know what? I think is enough. I think I
Yeah.
think we've had enough. I've had enough of you. That's for sure.
Okay, we're going to adjourn this portion of the hearing. Lieutenant Governor is coming in now for our assembly, and after Lieutenant Governor, we will quickly re-adjourn for the continuation.
You can stay.
You can stay if you like.
Oh, we can.
Are we still live? I can't hear anyone.
Okay, let her talk and let her.
Yeah, we're waiting for Lieutenant Governor to come in.
Okay, got it. Thank you.
To order, and I recognize Councilor Hurley to lead us in the prayer and pledge today. Here we go.
Thank you.
He's gone.
Governor. In the
There
name
he
of Father,
is.
Son, and the Holy Spirit.
I love
Amen.
Zoom.
Marilyn, I'm trying to say a prayer. Can you hear me?
Yes, we can hear you.
Okay. I'd like to offer a prayer today for all of the people who are still suffering the effects of COVID, especially the fear that's attached to Omicron and its rapid spread. I am hopeful and I pray that things seem to be going down in terms of the number of cases. I hope that this trend continues. And I pray that we do not have another variant that will cause more havoc. People are tired, they're weary, and they want things to get back to normal. So I think we should all offer a prayer to just ask that we catch a break and that things start to reverse. Amen. Thank you. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Okay, thank you, Counselor Hurley. I recognize Counselor Pereira for a motion to record advice and consent for the financial warrant.
So move, Governor.
Second.
There's a motion and a second. All in favor, say aye.
Aye.
I recognize Counselor Duff for a motion to record advice and consent for the pending list of notaries public and justices of the peace.
So move, Governor.
Second.
There's a motion and a second. All in favor, say aye.
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 We have a new nomination today. Joseph P. Hurley III has been nominated to the position of Circuit Justice of the District Court. That's in your jurisdiction, Counselor Jubinville. Do you have a date?
Another Hurley, we got Mary Hurley. we
Yeah.
got Pat Hurley.
For the record, absolutely no relation, although I'm only talking about probably 5 generations.
Yeah.
For that, we were all related.
Still related.
Yeah, I'll take that then, sure.
Okay,
I'll talk to the nominee. but-
Oh.
very good. There'll be a date and time of the hearing determined soon. That concludes our business today. It's a
Thank
short
you.
meeting. Thank you.
Thank you.
Governor. Yeah.
What are we doing now?
We're just waiting for the candidate to come back in and we're gonna just resume and go through this quickly.
I like the quickly putt.
If it's not done by 1 o'clock, are we breaking for lunch? Eileen?
Can you hear me?
Yes.
Yeah, I think we should be done by 1 if we can get everyone back in here.
I like the fact that you're a dreamer.
What you focus on expands.
So is Mr. Padden gone?
Counsel Fiera, are you online?
Yes, I am.
I am going to start with you. Do you have
Well-
any questions? Oh, no, I'm sorry. I'm a liar. I know, I'm so,
She's
that-
waiving her statement.
yeah,
Waiving a statement.
that-
Get right into
that
it.
was such
Seriously.
nonsense we just went through.
We've done that
Um,
before. We
Yeah,
can waive-
I'll be, in the interest of time, and I know this has gone on a very long time, I'd be happy to waive my statement.
Yeah.
Just say,
Yeah.
thank you to all of you for hearing me and.
We've
and-
read
Right,
your
we've read it.
material.
All right,
read
so I'll
everything,
just,
so
I'll get the
I
question.
don't have any questions. Do you have any questions?
No, I
Okay,
don't have-
okay, wait, let's go on to Counsel Fiera. You can start your
Thank you.
questions, Counsel.
Thank you so much. So the good news is I don't have any questions either, only because the nominee and I have talked at length for several days on end. And again, she has the support of people who I respect and admire in the House, including Representative Haddad and Representative Fiola, who called me yesterday. She also has the admiration of Miss Walsh Perino, who's the Register of Probate down in beautiful Barnstable County. And I've got calls from other judges and attorneys as well. She has a superb, stellar reputation with all the people I have talked to. And she has my support to be the clerk of the Gardner District Court when we take a vote next week.
Thank you.
Thank you, Counselor. Counsel Hurley.
Thank you. I think we need to go a little bit into what this opposition was all about. So I'm going to ask you some questions.
Counselor, I just have to note that this is an open case, and so she may not be able to answer some of the questions. So just be aware.
I'm going to ask the questions and we'll go from there.
Okay, no, I just want to, I just, if they're not questions that she's able to answer because of the open BBO case, I just want to make it clear why. Okay, go
tell-
ahead. Thank you.
All right. So your brother and his wife get a divorce. And in that divorce, who was supposed to make the payment on the mortgage?
At that point in time, it's a little bit confusing. She was initially ordered to pay the mortgage with the alimony payments. A few years after they were divorced, it came to pass that she wasn't paying it, that they had to do a mortgage modification, and that he was to take it from her alimony. That stopped in December when she got remarried. So at that point in time, it would have been the obligation of his ex-wife and her husband.
And she was not paying that mortgage.
No, she did not pay it. In fact, I was advised by my husband, my brother, that in January, when they should have started taking over the payments, she contacted him and said they were short of money from the wedding. Would he pay at least one more month's worth? And he said no.
All right. So was the house underwater at that point in time in terms of the mortgage and the value of the house?
I can't even really say on that fact. What I can tell you is that at the time of the divorce, the house, they owed about $475,000. Because she had not paid it and because she had other liens placed on the house, that it had to have a mortgage modification. So at the time that they bought it or did the short sale, it had gone from $475,000 to $543,000 maybe.
For the mortgage?
Yes, because she had to do a mortgage modification because she hadn't paid the mortgage consistently.
And what was the value of the house at that time?
At the time of the short sale, I guess I need to know which time period you're talking about.
At the time of the short sale?
I have no idea. My brother never got any information on it because all of the mail was addressed to Patrick Curran and Joan Curran at that home address. When I spoke with the lender, trying to get some documentation for my brother, they said they didn't know they were divorced, that they had always sent all the information to that address. So he never saw anything. I can't really speak to what it really was worth at that point. But I can tell you that I approached her with regard to a contempt of the divorce agreement because it was set out in the terms of it how they were to sell the house, which would have meant they would have each gotten appraisal.
All right, so you were talking about the divorce agreement or judgment, and they were supposed to each get an appraisal,
Mhm.
and they got an appraisal. What did your brother do?
He didn't know anything about it, so he didn't get anything. He didn't know about the short sale till it had already taken place, really. It
So
was, it was
the
after
fact.
she was remarried and after he had transferred his interest into his former wife.
All right, so did you go to the trustee in bankruptcy?
No. Actually, and I have some documentation of this, when I sent that letter regarding the contempt, it was after my brother had gotten the discharge in bankruptcy. The trustee filed an adversary process. I wasn't contacted to send anything to her until, I think we figured out, I have an email, it's about a month and a half after they started it.
They
And
started,
she-
the trustee
and-
started,
After she had started the adversary process. About a month and a half later, I had gotten a message from her. I'm believing that my brother told me he had talked about it during the trustees meeting, that I had information or something. I don't know. I don't know how she did it, but she contacted me after they had already started it.
and it wasn't you that contacted her?
No, I have an email from her saying I'm responding to your message.
All right, and there's been no hearing on the Board of Bar Overseers?
No, they're very behind, I guess. I only gave a statement in December.
Of this year?
Yeah.
Excuse
Yeah,
me.
2 months ago, yeah.
Okay. All right. And why do you think that you would make a good clerk?
Well, I think that I have, as you know, I've been an attorney for more than 30 years, and I've been in private practice for a little over 30 years. I don't have a history of practicing that's completely focused in one area. I've been to many courts, but at this point in my career, it's primarily I've been in the probate and the district court. I think as one of the witnesses, one of my frequent opponents has told you, because of the nature of domestic relations matters, you sometimes have dual matters going on at the same time in both courts. I think that in addition to having the knowledge, the legal experience, having really worked on both the reform, the lawmaking side, as well as being in the courthouse in the trenches over the years, I see the need for somebody to be, who is the clerk magistrate, to have sufficient knowledge, but to also have impartiality and the compassion and the demeanor that I think is appropriate when you're serving the public. And I think you and I talked a little bit about that. I have always been very impressed in those clerk's offices where they don't act like they're doing me a favor as a member of the public to help me. I think that you want to have I think I would try to create a culture where there was a much more public service oriented attitude in the clerk's office than some other people might, but I think that's a huge important factor when you're serving the public.
What do you think are the most important attributes of a clerk?
Well, I think that your temperament is huge, whether you don't want to be someone that flies off the handle either at the public or at the people that you're managing. I think that you need to have sufficient knowledge of the law and procedure. I think you have to be impartial, and I think you have to do what is right, regardless of whether it may be popular or not, but you have to do what the law says and what is right. But I also think there has to be a degree of compassion at the clerk magistrate level, because it is kind of set up to have that, to see if there's a way to steer someone in a different direction by either a continuance or some other method. And that, I think the overall positive outcome for a lot of people that come before the clerk magistrate is they don't do it again, they learn from it, but they're not permanently harmed like they would be maybe if they went through all the way to a conviction with regard to getting jobs in the future and such.
So you give people a break if it was a first offense?
I do what I believe is fair, yes.
So you have empathy.
Mm-hmm.
I know you waived your opening statement, but who's there with you today?
Okay, I will start over here. My husband, Stephen Harrington, is here. My friend and office manager, Joanne Foran, is here. Next to her is a colleague that I practice with in the same office space, and we often work together on things. Behind her is Chuck Walkovich, who is married to Joanne Foran. He, I think, maybe drove today. But he is also, he's also been my campaign manager over the years. My brother-in-law, Joe Crevo, and my sister, Nancy Crevo.
Your brother, Curran is not there today, Dr. Curran.
No, he's not. It would have been difficult for him to come.
Okay, all right. And what is the first thing that you would do as the clerk of the Gardner District Court besides go and buy furniture?
Well, depending on how busy a day it was, I guess I would love to at some point have, very early on, have an opportunity to talk to everyone who is there, who would be on the staff, and let them know a little bit about myself. But over the next few weeks, I'd like to talk to each of them privately, find out what they think is working, find out what they don't think is working, and try to come to some idea that if there's any improvements that could be made within the confines of what we can do, I would try to work with them on that. I also think I would talk, privately that first day with the the first assistant and assistant clerk magistrate, and try to develop, I think the best idea would be a rotating schedule, because I think if you just do one aspect of it all the time, and I know there are certain clerk magistrates that don't even go in the courtroom ever, I think you need to keep fluid and do every aspect of it. And I don't want to take that away from them. And I too want to learn all aspects and become comfortable in every area. So I think that would be important the first day.
So you're talking cross-training?
Yes.
Okay. You love your brother a lot?
Yes, very much so.
And probably wouldn't have gotten involved if it wasn't your brother. Is that correct?
It's absolutely correct.
All right. Well, I love my brother and sister. And I would get involved in something. I think you made a mistake, but somebody once said, to err is human, to forgive divine. So I have no more questions. Thank you very much.
Thank you.
Thank you.
Thank you, Counselor Hurley. Counselor Kennedy?
I don't have any questions for you. We've had a number of conversations, and I'm satisfied as to your qualifications. It's very clear to me that what we saw today was just a vindictive family dispute. And I put no credence or give any credibility to anything that was testified to in opposition. I think you're going to be a great clerk magistrate.
Thank you very much.
Thank you. Counselor DiPaolo?
I'm sorry, I spoke with Councilor Iannello this morning as well. He wanted me to indicate to you that he was going to be supporting you as well. He's not available today.
Great, thank you.
Sorry.
Counselor DiPaolo?
Thank you. Good afternoon.
Good afternoon.
Heard from a lot of people about your nomination. We got a lot of letters. I know you're a state rep, so I'm not surprised to see legislatures chiming in for you. The one that meant the most to me was Senator Goby, because I think she's someone who, in our partisan environment, finds compromise, is
Yes.
pragmatic, works with
Yes.
people. has compassion, and so for me, her recommendation goes a long way. I do want to ask you while you're here, you've worked on the criminal justice reform package. We heard
Yes.
about that. We heard others speak of what it entailed. What was within that package? What do you think was particularly impactful or was a particular priority for you? And if you could kind of talk about how it might inform your work as clerk
Okay.
magistrate.
All right, so there were a few parts that I kind of were very important to me. I mean, it was important all over, but I felt like after listening to a lot of testimony from people that had been involved in situations with mandatory minimums for very low-level offenses, and there was instances over and over again that it was part of plea deals. It was used as a negotiated tool often for people to plead guilty. You know, if you don't and we get you, we're going to do this. And I don't think that was what it was ever intended for. I think when it was started, it was intended to sort of, you know, slow this tide of drug cases coming through. However, it didn't work, clearly. And so I think what we did at that point is we tried to, I think it was so important that we removed them from the lower levels. But the newer drugs like fentanyl, carfentanil, not even scheduled yet. We needed to do something, especially that was during a period of time where fentanyl and carfentanil were taking lives at a feverish pace in the state. And we knew we had to do something. So we really went after traffickers, not users. And I think there's such a huge distinction there, so that the mandatory minimums got tied to the amount, but the amount got tied to whether it was a trafficker or a user. And I thought that was really important. I thought one of the important things to me was exploring the emerging adult justice programs in our system. I had been involved with a delegation that went to study that over in Germany, and where they are doing that. And I feel like that's really important too, because we have that sort of delta where our, you know, research and such will tell us that brain development isn't quite there yet, but they're not juveniles, you know, so they're in the district court, they're in that 18 to 23. Some people say it's higher, but I think we usually think of 18 to 23. And I know I had spoken with my Middlesex County Sheriff, and he agreed. He's actually started one of the pilot programs in his prison for that reason. He also did a veterans section. And again, we're learning so much about, you know, veterans coming back, especially from the past war, that they, you know, that we need to work with them maybe slightly differently. So I thought those were important. I thought getting rid of cash bail was really important for juveniles especially, even though that won't be my area, but that was something that was really important to me as well. And putting the limitations on solitary confinement. I'm sorry.
No, it's good. So as far as what you just talked about with emerging adults and such, I know that it's a piece of legislation that's proposed now. Was it in consideration in that package to raise the age of juvenile jurisdiction?
It was in the area, and we did lower, I mean, we did raise it in certain circumstances, but there was not unanimous consent to raise, and just because of other implications. For instance, even in a sort of a different scenario, we used to try and sentence 17-year-olds to adult prisons, and it became illegal at the federal level. So we would have either had to make a court just for 18-year-olds, you know, 17 and 8-year-olds, or I mean, a prison, or we needed to up our age to agree with the feds. So there was discussions, and one of the other things is out of that conference committee, we established other commissions to look into issues, and those commissions are actually still coming back to us with information.
So from your testimony today, am I accurately inferring that when it comes especially to show cause and initial charging, that your priority would be diversion, especially in the instances of substance abuse?
I would take every case as it comes, and I would take every fact pattern, and I would take into consideration candor. You know, if somebody realizes that they did something that they probably shouldn't have, but they get a warning, so to speak, or a break, and said, you know, I'll continue this for 6 months, and if it doesn't happen again, it won't be on your record. I think that some people say, oh, there should be more punishment at that point. I disagree because I think in the long run, if they get that compassion and if they get that consideration at that level, they could go on to be a much more productive adult in society. And that's what we really want. We don't want to ruin people. We want people to improve. And so I think that's a really great opportunity for the clerk magistrate.
I don't think any of us want to pay $90,000 a year to have someone incarcerated who's dealing with substance abuse issues, who's clearly on a path where alternatives would be better for everyone.
Right.
I have no further questions. I appreciate your time this afternoon.
Thank you.
Thank you, Counsel. Counsel Jubinville?
I'll just say one thing, the power of a clerk. I had a case one time with a young fellow who was accepted at the Air Force Academy. He got into a little jam in the summer for a clerk. That clerk had issued that complaint. He would not have gone to the Air Force Academy. Today, he's flying jets for our United States Air Force. Of a clerk gave him a break like that. So that's the power you have.
Thank you.
Thank you very much.
Thank you. Counsel Devaney?
Thank you. Oh, nice to see you again.
Nice to see you.
I have to say this is incredible. 22 years I've been meeting with everybody and the diner was closed. There was some problem with the snow on the roof, but we managed someplace.
We managed.
The other thing is we had to cancel the first one because of the
blizzard.
ice and snowstorm. So thank you. We did get
Thank
to
you.
meet. First of all, you've got the age that I want. 61. You've seen it all.
You just looked over at me like, oh, she's old.
You have the life experience that we need.
Mhm.
You're not going to learn on the job. You know it. And okay, first of all, I got to tell you that I believe that you should be a judge. There's no question in my mind with your qualifications, with the cases you've had. And I'll tell you, I'm impressed with your writing. And this past year, I've had a couple of J&C questionnaires that when I met with those nominees, I said, I don't know what the cases were. He hit this person and then he was acquitted. It was nothing. But you wrote and I understood and you in depth. And I love your writing at the end. Okay, so let's go back because I asked every nominee this. I want to know your journey getting here. Okay. So, first of all, you have applied 1, 2, 3, 4 times. 3 times for judge and 1 for magistrate. And for the public, in the J&C questionnaire, the nominee is required on question 47 to put the judgeship of the clerk magistrate that she has applied for, what year, if the J&C approved, if the governor approved. So, okay, so I just want you to know that. And I have to say this for the public because it really is amazing. We had this fella, 40 years old, who had 2 jobs coming out of going for a judgeship, going out. He had 2 jobs coming out of law school. One was one of 13 assistant solicitors in a city hall, and the other he worked for the sheriff. He had never seen a criminal case, very little, nil for court experience. So anyway, I said to him, did you ever think of applying for a clerk magistrate? I did. And I says, you're required by penalty of perjury to put that in your questionnaire. Why didn't you put it in? I didn't think clerk magistrate was judiciary. And he's sitting in the Worcester court as a judge. Imagine that. So anyway, and he was interviewed and he was, he wasn't appointed as a clerk magistrate. So he came back to the same J&C. Wasn't qualified for clerk magistrate, but now he's qualified for a judge. So having said that, you should be in the Worcester court. We need you with your criminal experience, with your civil. So when you applied to these judgeships, you were 55, you were 56, you were 57, and then for a clerk magistrate, 59. So thank you for your perseverance.
Thank you.
Now, let's go back to the present time. And how many, now, first of all, for the public to know, 21 lawyers in the state of Massachusetts are chosen by the governor. What an honor, an awesome responsibility to have the responsibility to decide who they're going to interview, the clerk, magistrate, or judge, and they make the decision and they vote and give that name to the governor.
Mhm.
We don't have that authority. We are given one name and we vote yes or no.
Mhm.
21 are appointed for that awesome position. How many were there at your hearing?
I want to say 8.
8. And I'm saying it publicly, not for the council and not for you. It's a disgrace. It's a disgrace. When you have 21 people voting for someone they haven't seen, they haven't heard, they haven't talked to, 8 take away 21, what, 13? If my math is right. Math wasn't my best subject.
Nor mine.
But I'm just saying that it's not the government I came in. I came in with the best, Governor Salucci. And I know you're a Republican. I'm a Democrat. Doesn't matter. We go by who the person is. And he was the finest, fairest, honest person that this Commonwealth ever had as a governor. Okay, having said that, now I want to talk about your writing here.
Okay.
You have done so many pro bono, so much pro bono work. We don't see that with someone 40 years old. They don't have time for that. They don't have time for that. They work at a city hall and they get their job and that's it. But I wanted you to talk about that because it really touched my heart, that little 5-year-old that you had in that case. So let's go back to that writing. And I'm going to tell you, you know how to write. And that's what you need in a judge, to write.
Right.
So let's get back. You're going for a clerk magistrate. Okay, so tell me about that. You were guardian?
Yes. Yeah.
Okay, so first of all, for people who don't know, tell us what that position is when you take that.
Okay, so a guardian ad litem is somebody appointed by the court to represent the best interests of either an infirm position, incapacitated person, or a child, especially in the probate and family situation. In that particular case, I do have to say I was paid something from those parties. They're required to pay me. Although I think my husband would tell you and my office manager that I never billed out for the hours, the many hours I did it. I tend to be, you say, a good writer. Well, sometimes my GAL reports would be like 75 pages. So maybe I went a little overboard sometimes, but I always wanted to make sure that I went through every detail and that I had enough evidence to assess credibility. And in the particular case that you're talking about, this girl needed a voice so badly. And I ended up arranging to go visit her at her daycare. And I asked the teacher to stay and be present. And because of the fact that I didn't want her to be intimidated by my constantly writing, I said, I'm just going to record it and then I'm going to write it down later. So
That was excellent to
yeah.
do.
So anyway, as the discussion went on, it became very clear that the mother was very abusive and the kid gave great intricate detail of certain situations so that it was, I didn't have any, if she was crying, I didn't have any reason to believe that what she was telling me was not true. Her credibility was excellent. I had issues with the credibility of the mother. And as I always say to people in those cases, I'm going to ask, they'll say, what does that matter? A certain question. I'll say, well, it's not that it has that much to do with the final decision on something, but I always want to find out if you're telling me the truth on a small thing, or if you're lying, that will be indicative of what you're going to do on a big thing, and I'll figure it out. And I had caught her on several mistruths. So the kid, I really felt she needed a voice, and as did the teacher. And I ended up filing the 51A. It did go to trial, and I testified, and the child went with the father, who was
Well, you
much
got to tell
better.
us the story for people to know, the public, what happened to this child. And how, you were worried about whether she would be able to speak because she was very, withdrawn. But she did,
Yeah.
and you prevailed. Would you
Yeah.
tell us what it was all about?
The parents had not been married when they had her, so under the law, the custody automatically goes to the mother. But the mother was not really leading a lifestyle that was supportive of the needs of the child. And it eventually turned out that she was doing things such as smacking her head, pushing her against furniture, and the kid was only 5 years old. And the first opportunity I had to speak with her was obviously in the presence of the mother, and I could tell she was very afraid. So it wasn't until she was out of that situation, and she made it very clear. I remember on the recording, she was crying, but she was saying, I want to live with my father, be with my father, live with my father, be with my father, live with my father, be with my father. She repeated it like 4 times in a row. And I was like, okay, I get that. I'll remember you said that. And I was able to testify to that to court and how she had been injured physically over the years. And there was just a much better, wholesome environment, I guess I could say, at that point in time for the father. I know that she changed into the father's school district. I think she's now out of high school. I
Wow.
forget when I did it. She's either in high school or out of high school, but she thrived in the new environment after being really abused as a small child.
It seems like we live in a society where this isn't uncommon, that children are being tortured, missing,
Mhm.
and it just breaks my heart.
Right.
And I don't
Right.
know, it's a sign of the times or
Right.
what it is, but yeah, you have had some really high-profile cases too. And the thing is that, you know, and when you talked about, it asks you what the greatest challenge of the court, and we've heard it, and you've told us, drug addiction, alcohol addiction, mental health issues.
Yeah.
And you said we have come a little way in helping suffering from mental health issues and PTSD and depression, as well as autism and other mental, emotional, and developmental disabilities. But I want to know, what will you do about it? These are the challenges. How will you, what could you do about it?
Well, and I want to
What
get
should
there.
be done about it?
Right,
I mean, as a clerk magistrate, you're
right,
not going to be able to do it all.
I think that what is an important thing is to be able to get people to the right resources, okay? And so I think that the hybrid of my experience being in the courts and in law, but also being in the policy-making end of things from, lawmaking end of it, that we are offering more and more opportunities for rehabilitation in those situations. And I think there's an understanding in like, drug addicted or alcohol addicted or veterans. Those are things that we now know, maybe we can take them into a different area and look at them. The other thing that I really support is what's called restorative justice programs. I don't believe they yet have that up and running that much in the Gardner area, but it is being adopted by more and more communities. I know our police chief in my town was hugely supportive of restorative justice, and there's a trainer in our town actually for the same. But restorative justice goes back to a very simple concept of when somebody does something like vandalism, okay, and say they're in that 18 to 23 kind of thing, okay. It would be sometimes a stupid thing that they did, like a very stupid thing, okay? And what restorative justice is, it makes them kind of see the impact on who they did it to, meet with them. It's almost like a mediation kind of thing, but also it takes it a step further. They not only see what they've done, they apologize, and then they make it amends on it. They make it good. And I think I've heard of so many successful stories of people on, on both sides of that, then later becoming very good friends and working together. There's all sorts of great stories, but that would be something that I think can also be utilized in the district court level, and it sort of avoids the process completely, so that there might cases we could refer to that type of work.
So how many cases would you say you've had?
I don't know. A basement full. I
You
have
can't-
a
you can't count.
storage
You can't-
area.
I
I don't
mean,
know.
We're talking 36 years.
Oh,
you
yeah.
know? I
Yeah.
mean, and I'm angry when I see your J&C, how you've been rejected for a judgeship. I am angry, okay, because it's ridiculous. Now, tell me about, you've done it all, mediator. Tell us about that.
Well, I actually decided to become a mediator about 15 years ago. And in some circumstances, that's a great way to resolve issues. Sometimes it's not, though. And I'll tell you, I've actually discussed this with clients before. And in certain circumstances, people have relationships where one is going to be a little bit of a bully. And when you mediate, the mediator cannot act as an attorney, so that you kind of have to let the parties, sort of run the show a little bit. I mean, you can say, okay, no foul language, or, keep your voice down or something like that. But I find that in certain circumstances, especially in situations where it works, I think, on business disputes. I think it can work on young couples getting divorced that don't have assets or children to really worry about. It's a quick way to get things done. But there are times that I wouldn't recommend it, and there are times that I would. So it serves its purpose in a lot of situations.
I'm impressed that you 15% of your time is pro bono, the people who can't afford a lawyer. And we have seen that. I have been looking into the housing court, which really is offensive because there's a lot of false foreclosures. And that's the problem. They're pro se, they don't have a lawyer, and they're vulnerable.
Right.
So I think it's wonderful that you have done that. I wish more would have done that. So what would you say was the most rewarding case that you've had? Is there one that stands out?
There is one that I did several years ago where it was both probate court and district court, but the husband was very wealthy, high wage earner, but very, very abusive. Actually was trying to choke the mother to death, and the son got involved, who was like a teenager. Anyway, he ended up calling 911. He got injured actually trying to break it up. And it was a mess from the day she came through the door. This had already occurred. He was, charged with assault and battery, and there was a restraining order from him to stop harassing her. And he just kept doing it, but he had her so afraid that she couldn't be out on her own taking care of herself, that she needed the money for, child support to keep everything going. And finally, it was too much. And she finally said, enough is enough. And he had sent her these messages like, oh, if you testify tomorrow, you'll be penniless, you'll be homeless, you can't have me go to jail. And she actually went in and still testified against him in the district court on the violation. And it was important to me on that one because she then started to really blossom. She got a job. Her kids are now out of school, and I keep in touch with her, and she's doing really well. And she said to me at one point, you can't put a price on your respect, self-respect, and dignity. And I was done with him trying to keep me down. And that one really made a huge impact on me, I'd say.
Right. We hear a lot about bail, and you've been involved in bail reform. Tell us about it.
Well, I think one of the most startling things with the bail reform was the studies that we had seen done. The Harvard study hadn't come out yet, but um, one of the most glaring things, I think, was the discrimination within the system. That the numbers just really came out there that, you know, more black and brown people were being put through the process than white people. That's the easiest way to say it. But it sort of became the springboard for a lot of work to correct that. And to make bail a more, and there was also a significant case that had come out right before then. It's called the Brangen case, but that really honed in on what it always should have been, but it really made it crystal clear that you can't really put a cash bail or a bail number higher than what's necessary to assure that that person will come back. That's the whole reason for it. I mean, you'll have some people that can't have bail because of dangerousness or whatnot, but for those that bail is an appropriate thing, it has to be looked at through the lens of only so much as is needed to assure that they'll return. And that's really different if you're 20 or 50, $5,000 to someone is 5 million to somebody else, right?
yeah.
So, it's an impossible reach for them. So it really has to be paid attention to, that it's not, bail isn't supposed to be you punishing someone for being arrested. It's
Well, you mentioned
yeah.
Peter Katusian, Middlesex Sheriff.
Yes,
I want
yes.
to tell you, he talked with me, and high regard for
Wow.
everything you've contributed. And the veterans have been kind of left out, and so now he has
Yeah.
he has developed a program that's really great.
It's great.
And we're really proud of him
Yeah.
in Middlesex.
Yeah, he's done a
Um,
great job.
Now, when you look back at these 36 years, there has to be one case that stands out that was so upsetting, the outcome of it.
Oh, yeah. Yeah, I can pick one right at the top of my head.
Which one is it?
It involved children, and it involved a very abusive father. And for whatever reason, I felt like it was like the hot potato nobody wanted to keep. It kept going from judge to judge to judge. And there was at one point, and I kind of threw up my hands, the probation department had made a recommendation he not have the kids be near the kids without proper supervision. A DCF, I think at the time, said he shouldn't be near them at all. The kids had been with him and continued to be physically injured. And he had a friend who was supposedly supervising. And after the judge heard all of the things that had happened to the kids while in his care, the abuse, the judge said, called up the woman who was the supervisor. And she said, now, are you still willing to supervise given everything that's been said about you here? And we're all looking at her like, and then the woman said, sure. And she goes, okay, well, I'm going to let you to, but I don't want you to get physical with the children anymore. It was so upsetting that the probation officer actually came out of the courthouse and ran around the corner of the building after me. Because she said, what in the heck happened? It just flew so in the face of safety. And that even though I no longer represent that person, I keep in very close contact with her. And those children actually ended up trying to run away at one point to get home. They rode their bikes. They were like 7 and 8 years old. They rode a couple of miles at nighttime to get away from him. Son is having major psychiatric issues, and he just won't give up. He's just, and that it bothers me. It bothers me when the facts are so controverted, and I do, I don't I think my office manager said that's when she's mainly seen me get upset, is when I feel like I've seen a real miscarriage of justice, and that one was
Well,
one of them.
I don't vote for anyone if they don't have compassion and empathy, and you certainly have it.
Thank
And
you.
in your own personal life.
Thank you.
Now, talk about your own, you have 3 children
Right.
and all equally loved.
hmm
Tell us how you happened to adopt your 3rd child.
Oh.
Now, those are biological. The other.
Yeah, I have the oldest and the youngest are biological, and I have a middle child who was adopted. And the way that it occurred was she had come from a very bad situation. She grew up in Arkansas. Her mother at one point had tried to kill her, had her locked in the basement. She made it away to some people that she had previously known. They helped her out. She was only 17, but she'd gotten into this program that my son was in at Carnegie Mellon for acting. And they had to have her become an emancipated minor. Her mom had her skip a year of school at one point. She's very young and for her age. And she'd gone to Carnegie Mellon without a degree, without a high school diploma. And the school said, well, you got to get it within 2 years. She didn't. So she had to take time off. And then she was in my son's class after that, who was a year behind. So she had nowhere to go over Christmas time because she stayed in the dorms and they closed over Christmas. So he felt bad because she just stayed in people's apartments to just, finish out the Christmas break. So we had said she could come, and it was just kind of I mean, my husband's here too, so he knows all of it. But it was just an incredible experience. We don't know what came over us, but it was a big change for the whole family that we really loved her very, very much. She then lived with us when she wasn't at school, and then we legally adopted her in the courts in 2010. In December of 2010, but she's doing great. She was just in the show Assassins in New York, and looking forward to other
And,
things.
I don't talk about someone's personal life, but I knew that you would allow me to
Yeah.
have you talk about that. I just thought that was
Thank you.
wonderful. Now, we didn't, maybe, I'm sure it existed years ago, but nothing to the amount of cases that are going on now, talking about human trafficking.
Mhm.
And talk about those things that you have championed for human trafficking and transgender equality bill and statute of limitations and child sex abuse, the bills and criminal justice reform. This is what you bring to the court. And all of that knowledge should be a judge. Okay, all right, tell
Maybe.
us about that.
Maybe
Tell
yes.
us. Tell us
Yeah.
about that.
Well, as you said, the transgender equality, I think Councilor Duff brought that up. That was something that I have to confess, when it first came through us, I didn't vote for it. I didn't support it. And then I realized I was wrong. And I listened to way, way, way more testimony over the next 5 or 6 years. And I admitted I was wrong, and then said, this is why I was wrong, and asked people to support that bill. And worked very hard on that. And then the human trafficking was also a big one, and it was a real eye opener. My kids always they thought that I spotted trafficking everywhere. So that's a hotspot of trafficking. And there's one particular community down the Cape that is one of the biggest trafficking areas at that time, anyway. And I would never let my daughter go there unless I drove both ways, even though she was in college, because I'm like, oh no, there's human traffickers. The cab companies, a lot of people that gave rides were involved in human trafficking rings. So had to be really careful with that. So that was good. It kind of took the focus off the victim, which is the person being trafficked. It sort of took the criminal onus off of them, and it put it on whoever was doing the trafficking in a much more efficient way. And the sex abuse statute of limitations was because a lot of people don't come to terms with what's happened to them until they're in their 40s sometimes, even if it happened in their youth. So we needed to extend it to a practical number, but also had to be conscious of, the defendant's ability to put on a reasonable case because of age or infirmity. So we had to negotiate. It took us actually into a second session to finish that conference committee to make sure we got it right.
You've had so many cases in 36 years, so diverse. And I was interested in the one that you were representing someone, and they were both drug addicts. And
Oh, yeah.
that was an interesting one. Tell us about that one.
Well, it was both parents had severe drug issues, and I represented the guardian, which was the paternal grandparents. And the The mother actually was convicted actually of being out trying to distribute, sell benzos and amphetamines one night in January with the small child in the back, and she got arrested and such. My clients became guardians. Well, the kids they've had the child for now over 6 years, the guardians. But at one point the mother was gonna get custody back. We'd signed an agreement, gave significant grandparents' rights. And when I went into court, it was, we just wanted to get it approved, but it had been our trial date, and the mother came in stoned out of her mind. So they didn't go forward on the agreement, and the judge started the trial but called a mistrial. And because I think she thought she was out of the woods, and it just wasn't a smart thing to come in and be out of your mind on drugs, so.
I've asked other nominees when it comes up. It just seems to me there's going to be a better way in court. Everybody comes in at 9 and everything. And you address that in your JNC questionnaire about staggered time.
Yes.
Tell us what you think.
Well, I think it's important, and I think it's something we've really learned from during COVID with Zoom calls. I think they have been much more able to say you're going to be 11:15 and really shoot to get you at least in that window at that time. They're not, you still have to wait sometimes, but it's much better than having everyone come in at 8:30. And the hard part about it is that if everyone comes in at 8:30 and you're not heard till later in the afternoon, your client really is paying the attorney to be there for a long period of time for maybe 2 minutes in front of the judge. So I think that using staggered times is a good idea. And I know Gardner is very good about separating days as far as what's what day. And they're still allowing for Zoom to be used. There's a lot of people that come before the courts, they have to lose a day's work to go to court. And sometimes they can arrange to do it by Zoom and not miss court. And that's, I think that's a good thing for a lot of citizens. They want that opportunity to get a day's pay, and we shouldn't really take it away from.
Yeah. You've been involved in a lot of, besides pro bono and helping people, a lot of civic things with Boy Scouts and Girl Scouts. I don't know how you find the time to do all of this, So,
Yeah.
have you been continuing that now with?
Well, the Boy Scouts especially, I've gone and spoke at their meetings to do, teach them government things and such. I also do Eagle Scout ceremonies.
Yeah.
And I speak to them, and give them a citation. And so I've just developed a rapport with the different Scoutmasters and such. So that's been a big one. For whatever reason, Girl Scouts, for some reason, hasn't asked me as often. And I did I did one this summer with a group, but they don't ask me as often, which is kind of disappointing because I don't know. I feel like, although I think I think Boy Scouts now it's now just called Scouts.
Yeah, right.
Yeah. So now I actually did an Eagle Scout ceremony a few weeks back, and it was 3 Eagle Scouts that were getting it. And 2 out of the 3 were girls. So it was kind of neat.
It's an amazing thing with our society that we do have boys that are Eagle Scouts to stay all those years and go through all of those ranks. That's an amazing thing. And parents should be proud for them to do that, not to beat a dead horse, but you applied all this administration and the same JNC has been refusing you. Did you have any feeling about going before them again?
Oh, well, obviously, fear and
but-
anxiety. I don't know. Nervousness,
Yeah.
So.
Well, I'll tell you, it was such a pleasure to meet you. The time just flew. And I can't tell you how happy I am and how sad I am because you should be in the Worcester Court and that kid should be a clerk magistrate. But I'll tell you, I hope, and I know if I'm talking for my colleagues, I hope we'll see you soon
Thank
to
you.
be a judge because you know the court, you know what's wrong, you know how it should be fixed, and you've gone out there with the sheriffs and everything, talking about these programs. And I'll tell you, one of the best I've seen in 22 years, Clerk Magistrate, God
Thank
love
you.
you. But
Thank you.
anyway, I'm very, we'll be voting next week and
Mhm.
I'll be very pleased. I don't have a poker face and
Thank
you know,
you.
I've been pleased. And it
Thank
was
you.
just talking about you and talking about your life and everything you've been involved in. It's just so impressive.
Thank you.
Thank you for all you've done.
Thank you.
Thank you.
Thank you.
Thank you, Counselor Devaney. I really don't have much else to say.
Thank
Being
you.
Irish and Italian, I can talk. But I think that this is one of the best nominations we've seen. Not only your 30 years experience in the district court, more recently in the probate, but you certainly have real deep roots at district court. But your experience on the Judiciary Committee too, and your understanding, having read some of the most recent studies, things that Council DiPaolo is so concerned with, as well as the rest of us on the council, I think will serve the citizens of the Commonwealth very, very well. So it will be my pleasure to put your name into nomination next week. And with that, this hearing is closed.
Thank you.
Thank you for coming.
Everybody have a good week.